Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
LJ commentary on the table. Dati mihi Anglican for his service.
Literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Great to have you here this morning. It's been a little bit hectic on this end, trying to get everything lined up just perfectly, as we try to do every morning.
Hello.
Let's see. We've got that there. Does that work? No, this does not work yet. Okay, we'll do it manually. Mommy Shar, congratulations. First in chat today. The internet is all yours. Everything up here related worldwide is your responsibility. Good riddance, I say. Good riddance. All right. Where are we? Oh my goodness. What? We have got so much going on. So much going on right now. We've got a lot happening right now. All right. And I'm waiting on calls. We're trying desperately to have South Carolina call us back. I've left messages and texts. There's only one person that can do what they need to do, and that person is not calling me back. I need permission to use a feed. That's what I need. I need permission. So we're waiting for that call. Am I ghosting you? What? You guys can't see me? Did I do it again today? No, I'm live. It's working. Didn't ghost you today. Can you guys see me? I show him on the air. Oh, why is SC ghosting us? Sorry, South Carolina. I was thinking Scott for some reason. South Carolina has started the Chow case, and we're hopeful to get in. We'll pick it up and catch up very quickly. That's the goal. In the meantime, we have a couple other things. We do have a thing going on in Warren County. We've got a thing going on over in Simpson's court, both trials today. I believe both bench trials. There's a Gregg argument. I'm waiting for a word back from the Mississippi Supreme Court, just to see if we can use that feed as well. So I'm monitoring that over here next to me, and yeah. So just a little bit going on. Legally Blonde is in our minds today. She's got her adoption thing going on today, and would appreciate some good vibes. Any thoughts and prayers her direction would be great. I'm sure she's going to do really well. Let's see. Integrationing. Thank you very much for the high five. Appreciate that. I think we're going to... Where do we start?
And eventually accused him.
Not that one.
26CR 43363.
Not that one.
Santana Diaz is present with her attorney, Nate Elter. The state is represented by Teresa Hyatt.
I think this is a pre-trial.
We're here for a hearing on treatment in lieu of conviction.
Yeah,
the report says she's denying she committed the offense.
So we'll switch to that. Okay, so Judge Simpson has not started his hearing. We have to do birthday stuff. Oh, I forgot. Oh my goodness. I forgot more than that.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. Meh. I got meh. This is my vote I got for my kids. I forgot it's hump day. We have birthdays to do. Let's celebrate those really quickly before we jump to start trying to watch the court. Here's what we're going to do. If we have to play catch up and run fair use commentary on Chow, we will. I will tell you the audio is tough. And by tough, I mean...
And hears them yelling,
you can
running after him.
But there's just...
Turns to see, and again...
Air conditioner just booming in the background. So it'll take some work to fix that. It'll be headache days, but we can make that happen. Unrulia Julia, today is my daughter's 14th birthday. She's probably on the form already then, right? I'm sure you already put her name on the form for birthdays. Or do you need to hurry and give us a name so we can add it? All right, we have Carl, whose 50th birthday is today. That's 80's brother. Carl is 80's brother. 80's Music Man. Elizabeth.
Happy birthday. You look good.
Miss Lily Wren. And Teenage Mutant Ninja Greeners. Carl says 70s Music Man. Older brother then, huh? That's awesome. There's a thing on your right earphone thing, like a string or a spider. Probably a spider. Thank you for telling me. Where do I grab so I don't touch it? It's literally just the headphones just falling apart on my head. It's a pleather. It's the finish on the pleather earmuff. That's what it was. Grab the Febreze. Yes. All right. That's your 13-year-old. Ninnis, thanks for the details. Good thing we're not in 4K, right? All right. Give us just a minute. Let's sing happy birthday to the people who need to be celebrated because we do have birthdays. Unrulia Julia, did we get a name from you? Brooke, it is. Brooke, it is. All right, here we go. Everyone, wherever you are, if you're able and it's legal, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. Warm-ups always go better after the hump day yell. I don't know what it is. Mrs. R.A. is on her way back from a hotel, by the way. She's going to be here in a minute. Happy birthday to you. Happy birthday to you. Happy birthday, dear Carl, Elizabeth, Miss Lily Wren, Teenage Mutant Ninja Greeners, and Brooke. Happy birthday to you. Teenage Mutant Ninja Greeners. Greeners, you know you can't put like 15 syllables in for a name. Teenage Mutant Ninja Greeners. Happy birthday, Teenage Mutant Ninja Greeners. And Brooke as well. Happy birthday to all of you. I realize there are many wonderful days, but today's your special day. And there are a million people you could have celebrated with and a million places you could have been, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn that joy back to you, make your day just a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Woo! Should be Greeners too. All right. Whew. Wow. So we're still, I have to take every call I get on my burner phone today because we have calls due back to us from courts all over the country. New trial to watch just started. Store clerk PPU shoots team. That's called South Carolina versus Chow. And it looks like this. We're very well aware of that one. Waiting for official permission to be able to use the feed there, the pool feed. Greeners gets to eat cake in a bowl with milk on it today. Awesome. Congratulations. You're going to love it. Dancing and Pancakes continues. 80s Music Man, OG. Congratulations. Happy birthday to your brother. If it's an older brother, is it 80s Music Man? Or if it's a younger brother, is it like 90s Music Man? Like older would be 70s, younger would be 90s, right? I guess if I do my math right. Okay, hang on. One hand, like the Def Leppard drummer. Yeah, there we go. All right. We can watch South Carolina v. Chow with the little square on our screen. It's right up there. That's it somewhere. I think it's that one. Yeah, I don't know. It's one of those up there. All right, but it's also here and there and everywhere, so we've got it. Clever Name says, throw up the feet under fair use and I'll provide commentary on offensive jokes. A tempting offer, but I think what we're going to do is this. We're not going to lose Chow. We might have to do a late start on Chow, meaning a catch up for a day or two. I'll keep monitoring that. Hopefully the audio gets better, because that's just the type of sound that they need. It's easier to fix in post than live, and it's a lot of work to fix in post. So I don't know. I'm thinking we're grabbing Warren County as well right now.
Right,
this guy,
not knowing it was
right.
a bad check, then you can have a trial on that.
You can have a trial. We're grabbing that. We're waiting for that trial to begin. And then I think the one we want to watch is Simpson, if he'll ever start, because we can't really grab that one and catch it later, because it's gone. When it's gone, it's gone. The audio is awful on that one. It is. Audio is terrible in Chow. And I was watching the cameraman do the audio check, and it's just a single mic on the camera, just picking up whatever sounds are bouncing off the walls. I'm like, no, please just tap in. And they didn't. They did not tap in. The audio is fine. Bap, I appreciate you having a lower threshold for acceptable audio. It's when I have it piped into my ears all day long, it's a lot. It's a lot to listen to. But we'll get it figured out. We'll do what we can there. Okay. Skybell, member for 34 months. Scott, you're the best. Time flies never dull. Thank you. It's fun. Mrs. R.A. Stayed at the hotel last night so she could drop my son off at the airport at 1 a.m. because that's when he got the flight. He was looking for the cheapest flight, and he got the cheapest flight. And just didn't bother telling us we had to drop him off at the airport at 1 a.m. in Raleigh. So I said, don't drive all night long in the middle of the night when you're tired and dark. Instead, get a hotel. And she did, and just got up. She's going to be home in about an hour. Anyway, that's the update for her. I'm so happy about that. And he made it on his flight, and everything's fine. DSN member for 39 months, both Skybell and DSN. OG. Original Goats, thank you very much. Gigi Sharebear, another OG. Good morning, all. Glad to be here with you. 32 months. 32 months. It's amazing. Chris Wallace, we just talked about it. It's this one right here. We're waiting. We've got calls in to get permission to use a clean feed on that. And as soon as we get it, we'll do that. So. Yes, you missed Mike. It was pretty good. It was meh. It was meh, actually. DSN gifted 5 memberships. Thank you very much, DSN. Appreciate that. I've had a lot of people even text me and say, just do it. Just use it. It's not a problem. No one was going to do anything. We operate differently here. I've got long-term plans for the channel, not just this week. And I'd like it for it to continue to exist long term. So,
Your Honor, people believe any potential conflict between this honorable court and the Office of the Public Defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
TTU Gator, OG, 23 months as well.
We also would join in the motion.
All right. The court also does not believe that the conflict exists either in the Michigan court rule or the case decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case People versus Derek Williams.
Morning, Your Honor. Raven Cook for the people.
Ron Brown appearing on behalf of Mr. Williams.
Your name, sir? Derek Williams. Thank you.
Derek Williams is charged with assault.
Move to dismiss the charges.
No.
People being unable to proceed this case is dismissed.
Assault,
without prejudice.
intent to do great bodily harm, less than murder.
Your Honor, can he go return his monitoring device? Heather.
That was quick.
You got to tell her? Yes. You want to keep it? No? He can go over to the community corrections. They should take it out.
Thank you.
I appreciate you.
Okay, so let's jump to Warren County, Ohio then.
Is represented by Aaron Aldridge. The state is represented by Brian Goodyear. We're here for a trial.
This is live.
Is the state ready to proceed?
We are, Your Honor.
All right, call your first witness. If you want to make an opening statement.
Judge, I can waive opening statement.
Okay.
Same, Your Honor.
Okay. Call your first witness, please.
Officer Antoine Scott.
No opening statements on either side.
Separation of witnesses, Your Honor.
Okay, that's granted. Who's your designated witness?
Actually, Your Honor, Officer Scott is the main officer, but he worked midnights last night, so I'm not going to make him stay afterwards. So I'm not going to have a witness in the courtroom with me.
Okay.
Okay.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Well, the first time he shows a video.
Morning.
Okay. Morning, officer. Please tell us your name and spell your name.
Officer Antoine Scott, S-C-O-T-T.
It's a good name.
And how do you spell your first name, sir?
E-W-A-U-N.
All right, thank you. Now, you're employed as a police officer where?
The City of Springboro Police Department.
And what's your current rank, sir?
Sergeant.
All right. How long have you been a law enforcement officer?
About 15 years now.
Have you worked only for Springboro or for other departments as well?
Also worked for the City of Middletown as a correction officer prior to joining Springboro.
Okay. So in active law enforcement duties have always been with Springboro?
Correct.
Can the defendant
And when
stop rattling his
to
chains,
be a
please?
sergeant, sir?
Officially Sunday.
Oh, well, congratulations.
He's been
And
on
I'm
the job
assuming
3
that
days.
you had to take a test and there are other qualifications to obtain that promotion. Is that right?
Correct.
And am I correct to say that some of those qualifications are your superior's view of the quality of your work that you've done as a police officer?
Correct.
All right. Now, were you so employed as a police officer with Springboro on January the 21st of this year?
I was.
And on that date, sir, did you come into contact with someone known, you came to know as Charles Cole?
Yes.
Do you see Mr. Cole in the courtroom today?
Yes, he's seated with the green jumpsuit.
Your Honor, does the record reflect that he has identified the defendant, Mr. Cole?
Any dispute about that, Mr. Aldridge?
None.
Okay. Granted.
All right, sir. So prior to the time you had contact with Mr. Cole, what were you doing that day?
I was on patrol and also training a new recruit that we had at the moment.
Okay. What was the recruit's name?
Officer Bradley Cooper.
All right. So you and the officer are, where were you located? You're on patrol, and at some point were you stationary?
Yes, we were. Stationary on 73 near 75 in the city of Springboro.
And at some point during the morning, sir, did you receive some information that began, I guess, an investigation for you regarding an incident that took place?
Yes.
And tell us about that.
I was made aware that Carlisle was investigating a possible stolen vehicle. They gave a description and also a possible suspect that took his father's vehicle and left in an unknown direction.
Okay. And do you know, or do you recall kind of generally what the description was of the vehicle that had been stolen?
Yes, it was the older model pickup truck, red pickup truck.
All right. And so you were stationed, you said at 73 near the interchange was 75, is that right?
Correct.
Is there a reason why you're at that particular location based on the reporting that you had received?
Yes, it's a common throughway for traffic coming from Carlisle, Franklin into the city of Springboro.
All right, so in case this individual in the stolen motor vehicle came towards Springboro, that's the route they would take?
Correct.
Generally?
Correct.
Okay. So then you're stationary. Tell us what happened next.
With the information provided, I ran the plate that Carlisle provided for a stolen vehicle through a database that we have access to obtain a photograph, an accurate picture of the vehicle. I did locate a photograph of the pickup truck on the system, so I was looking for a more specific.
Go ahead, I'm sorry.
I was looking for a more specific truck now that I had the photograph. Moments later, I observed a truck matching that description coming my direction. And once it passed my location, I confirmed the license plate that Carlisle provided.
Okay, so the system you're talking about, is that the flock camera system?
Correct.
Okay. So from Carlisle, you had obtained, from the reporting from Carlisle about the stolen motor vehicle, you obtained the license plate and the description, and then using that information, you located images of the truck that had previously been captured using the flock camera system.
Correct.
And then you use that as a guide to view motor vehicles passing you on the road.
Correct.
All right. And you said you saw a truck matching the photograph that you had in your cruiser. What action did you take then?
Once it passed my location, again, confirmed the license plate, I pulled out behind the vehicle to initiate a traffic stop as it pulled into the parking lot of Thornton's gas station.
Okay, Thornton's. So when you attempt to initiate the traffic stop, this truck then pulled into Thornton's?
Correct.
Okay. And the area that you saw the motor vehicle being operated and then finally stopped at Thornton's, is that in the city of Springboro, Warren County, Ohio?
It is.
Okay. So then once this truck stopped, what did you do? What happened next?
Prior to me calling out the vehicle completely, the driver exited the pickup truck and started to walk back towards my cruiser. And at that time, I stepped out of the vehicle to approach the driver in attempts to detain him for the investigation of the stolen vehicle.
Okay, let me stop you real quick right there. So you mentioned that you saw the driver get out of the motor vehicle. You previously identified Mr. Cole. Is Mr. Cole the driver of that vehicle that you saw that day?
Yes.
And he's the individual you had contact with that you're describing to the court?
Yes.
Okay. So then when he got out of his motor vehicle, what happened?
Initially, I believe his hands was in his pockets. I gave him verbal commands to remove his hands from his pockets and asked him to turn around in attempts to detain him, at which he began to, I guess, walk backwards or backpedal as myself and other officers attempted to go hands-on to detain him in handcuffs.
And what was your purpose in wanting to detain him initially?
To help the investigation of the stolen vehicle and for officer safety purposes. He was driving the vehicle that he just recently stole.
Okay. So you knew this individual is operating a reported stolen motor vehicle, and you need to investigate and also maintain safety for yourself and other officers.
Correct.
All right. Now, on that date, I see today you have a holder for a body camera. Were you wearing a body camera on January 21st, 2026 when this incident occurred?
I was.
Okay. And, sir, on that date, was your body camera active and operating properly?
It was.
Okay. And so the body camera that you were wearing, did it capture the incident that you've described here so far?
It did.
All right. And have you previously had the opportunity to see what's been marked as State's Exhibit 1A for identification?
Yes.
I showed you that?
Correct.
And was that your body camera?
Yes.
Okay. So, Judge, there is a portion of body camera from Officer Scott that I have marked as State's Exhibit. There's a USB State's Exhibit 1, and I have 1A and 1B, two videos on there. So I would ask to be able to play the first video, Officer Scott's video, at this time.
Okay.
And we would ask that you play it for us as well. Just got permission from Mississippi to air the Supreme Court arguments for Carly Gregg, who was appealing her conviction. She's the one who...
Excuse me for one moment. Pause that.
Yes, sir.
Appeared to coldly shoot her mother just off camera. And held the gun behind her back. Then invited the friend over to see. You remember that case. We followed it here. So we're probably going to be going to that in a little bit. That starts in 1 hour. So just waiting now for South Carolina to get their act together so we can jump down to, so we can take a clean feed on the South Carolina versus Chow, which is what we'd like. I don't know if she'll be present. I think she would be, possibly. I think she would be. Judge here calls an audible, mutes court, and proceeds to deliver a a soliloquy he memorized from Shakespeare back in grade school. Hasn't lost a bit. And now we'll resume court.
Actually, officer, before I show the video, let's kind of finish your description of what took place. So you said you get out of your vehicle once the truck stops. I think you said the defendant immediately exited his vehicle. Is that right?
Correct. Well, the vehicle is driving, correct.
And then what did you advise him?
Take his hands out of his pockets and to turn around, I believe.
Okay. And did he comply with your commands?
He did not.
All right. Now, we're about to see this, but, sir, on that day, the cruiser or the vehicle you're speaking of, we can see it on the video, was that a marked police cruiser from the city of Springboro?
Yes.
Were you wearing a uniform, as you are today, identifying yourself as a police officer?
That's something similar, yes.
Okay. But I know you're now a sergeant, but similar uniform, identifying yourself as a police officer
Correct.
as you approached him.
Correct.
Okay. And was there any obstruction between the two of you where he couldn't see who you were or what was happening?
No.
All right. So when you first instructed him to turn around, did he comply?
No.
What action did he take when you asked him to turn around so that you could detain him?
He began to walk backwards and kind of put his hands up in, describe as a defensive manner. And he went to obey commands that was given to him.
Okay. So when he refused to comply with your commands, what action did you take?
Myself and other officers attempted to go hands-on to physically detain him. And at that time, he resisted our attempts to detain him. And during the altercation, he reached out and grabbed my handgun. That's my duty handgun on my hip.
Oh, that's a
okay. So, backing up a little bit. So, you said you and other officers approach the defendant. Were you in front of him?
I was, yes.
All right. And where was the other officer?
Just imagine it's
Cooper
Santa Claus.
Was behind him, I guess to his left, and the deputy arrived also from the rear of his position.
Okay, is that Deputy Halsey?
Yes.
Okay. So, when you were first actually engaged in physical contact with him, your body weight was attempting to move his body in which direction?
Back towards the pickup truck.
Okay. So you're moving him away from you,
right.
Is that right?
Correct.
And the other officer you said was behind him.
Correct.
What was the other officer doing?
Can't say if he's pulling him or pushing him, but he's off to, I guess, my right, but to the defendant's rear left side.
Okay. So the officer was behind him, grabbing a hold of him in the same, and you're pushing him towards the other officer.
Correct.
And in order to be able to grab your firearm, would he have had to move against the force you were using to be able to reach out and grab your firearm?
Correct.
Okay. And when you say he grabbed it, describe for the judge exactly what you felt occur.
Felt a tug on the firearm, and at that time I did alert the other officers that, hey, he grabbed my gun and pulled my gun.
Okay. So this was not a touch, a brush. It wasn't hit up against it. You actually felt a tug on your weapon.
Pull, yes.
Okay.
Everybody knows.
And once you felt that, what happened next?
Verbalized to, again, the other officers that he pulled on my gun just so that they were aware that it kind of escalated for safety reasons. And at that time, we were able to get him on the ground. And once other officers arrived to assist, we were able to put him in handcuffs after a brief altercation on the ground.
Okay. So I'm going to show this clip of your body camera, officer.
Judge, do us a solid on this one.
Now, as we start, is that your mobile computer inside your car we can see?
Yes.
Okay. And on the computer, I see 3 different images. Is that right?
Correct.
What are those images of?
Those are images from the flock camera of the vehicle after I ran the plate in the flock database.
Okay. So it's a little hard to see because of glare, but the bottom line is, when you look at these 3 photographs, those are 3 different photographs of the actual truck that was reported stolen.
Correct.
And this is what we're seeing is you stationary at 73 near the interchange with 75, observing for that vehicle to come by if it were going to.
Correct.
All right.
I'm wondering if
And is that the
if the leg
trainee
shake is
officer that was with you?
a medical condition, or if it's just trying to get on people's nerves. He stopped now. He forgot to do it.
And why don't we hear sound right now, officer?
It's just broken. You didn't plug it in right.
The video footage goes back a minute from the time I activate the camera. Sound's not recorded, but the video is recorded.
And what causes the activation of the camera?
Either lights been turned on or taser deployment.
Okay. And in this case, it'd be you turn on your emergency lights because you saw the truck.
Correct.
Could be nerves.
And is that what just happened?
Correct. Yes.
There might be some language here, guys. Whoop, whoop, whoop. Just called in the plate
Judge,
number.
I'm sorry. Can you hear that?
He's reported the stolen vehicle he was pulling in.
Yeah, I just want to make sure you can hear it.
Yes.
'Cause we have that other, I can use the other speaker if you want to, but if you can hear it, that's fine.
Yeah, it's fine. I'll let you know if I'm not
Okay.
understanding it.
All right.
Judge, can we see it?
How's it going, man? Turn around for me. Keep your hands on your pocket. Turn around for me. Turn around for me. Turn around for me, man. Hey, turn around for me.
Now, observing that video, is it fair to say when you told the defendant to turn around, not only did he not comply, but he actually put his hands up kind of in a fighting stance?
Correct.
Okay. Now, initially, you mentioned what you're going to do if he had complied was to detain him to continue this investigation. Is that right?
Correct.
At some point, based on his actions, did you make the determination that you were going to arrest him instead of detain him?
Yes.
And when was that?
Once he stopped complying, wouldn't comply with my orders, and then turned around as he was instructed to be detained.
Okay. So at the time that he began to obstruct your duties, you made the decision that you're actually going to place him under arrest.
Correct.
Okay. I'm sorry, Judge.
How's it going, man? Turn around for me. Keep your hands on your pocket. Turn around for me. Turn around for me. Turn around for me, man. Hey, turn around for me. Grab my gun.
How long? What is it? Because he got that. How much he got the time when it actually took the time down? It looks like more than it actually is.
The defendant's talking in court right now.
So, obviously, officer, you're able to get him on the ground, but he continued to resist your attempts to arrest him. Is that right?
Correct.
Roll towards you. Give me the sword. What are you doing that? Quit resisting. I got this hand. I wasn't resisting. It was torturing me, man. It was building my bones and stuff.
Mr. Cole.
I wasn't resisting.
Mr. Cole, stop commenting on the evidence.
Okay, sir. Sorry about that.
This is their opportunity to present their side.
He's doing commentary during his own video.
Thank you, Judge.
I wasn't resisting.
So, officer, is it fair to say that it took, we see this sort of on video, but it took 3 of you to actually control him enough to place handcuffs on him?
Yes.
Brad Bear, thank you. 25 months. OG.
And he grabbed my gun for a second. No, it's what later just happened. You have your weapons on you? Hell no. No? It's already sick down to the fucking the real people, but the real guy. In the truck. You ain't got no fucking shit, man. I'm telling you, I'm the first one to my body. I ain't yielding to that fucking thing. Oh, I ain't yielding to that fucking
Now, as you, obviously, we saw in the video, you and other officers were wrestling with him, trying to get him under control. Is that right?
Yes.
And we hear you're breathing pretty heavy, so you had to expend a good amount of force.
Correct.
While this was happening, were you injured in any way?
Once I fell to the ground, I did have a slight abrasion to my right knee and a little discomfort from falling on concrete.
Okay.
Correct.
And as this was happening also, sir, the officer that you were with, Officer Cooper, did you become aware of an injury to him while this was all taking place?
I did. He advised that his shoulder popped out of place, out of socket.
Okay.
Ouch.
And so...
that one hurts.
Ultimately, that left you and Deputy Halsey then to finally control him because of the injury to Officer Cooper.
Correct.
Roll over. He's got me prisoner at the house. Roll over, man. I'm telling you, you listen to what, man?
You okay, Coop?
I'll tell you what, this is left. Wake up the morning, come on my leg. I don't motherfucker. 73 years old, he's no boy. Look at shit.
Yeah. That's you back there.
Assholes. God damn it, man. You guys fucking gonna pay for this, man.
Cooper said his shoulder popped out of place. Check on him.
Obviously, at the end, you're advising another officer about the injury to Officer Cooper that you've described.
Correct.
Okay. Now, obviously, we saw a video that, as you watch it, it's pretty quick, right? Everything happens fast.
Correct.
As you noted, immediately when when your firearm is grabbed, you say, "Hey, he grabbed my firearm." Right? So, you've also had a chance to see some photographs that are screenshots of the video, of your body camera video and Deputy Halsey's body camera video. Is that right?
Correct.
Okay. And first, let me ask you: the video we just saw, Stacy's Exhibit 1A, was that a fair and accurate depiction of the events that took place on January 21st, 2026, involving the defendant, Mr. Cole?
It is.
And then let me show you some photographs. First, just take a look at that for me. And Judge, if you need to stop to do the jury waiver, whenever, I'm
I didn't
fine.
want to interrupt.
It's fine. We can stop right here if you want to.
Okay, we'll just take just a moment here. Come on up, Mr. Belfry.
Appreciate that. Sure.
As Ms. Santana Diaz is present with her attorney Nate Elter, we had previously addressed treatment in lieu of conviction hearing where I brought up the fact that the report stated Ms. Santana Diaz was denying the matter. There was some discussion. She spoke with counsel. My understanding is she wishes to have a trial in the matter and you're moving to withdraw your motion for ILC. Is that correct?
Yes, Your Honor.
All right. Anything from the state?
No, Your Honor.
Okay.
It's nice to have a little break in the middle of the trial.
We'll set this for trial. You also indicated that she wants a bench trial, so there's a jury waiver that's been presented. Ms. Santana Diaz, this says you understand you have a right to have your case tried to a jury of 12 people, and a jury verdict would have to be unanimous before you could be convicted. Do you understand that? And this statement indicates that you're waiving your constitutional right to a trial by jury, and you're electing to have your case heard by the judge, who would be me. Correct? Is that your desire?
Yeah.
Okay.
Yes.
Do you feel that anyone, I want to make sure you understand, you have an absolute right to have 12 people hear this case, and before you could be convicted, all 12 of them would have to agree the state had proven the case against you beyond a reasonable doubt. Do you understand that?
Yeah, I understand.
And it's your desire to waive that jury trial right and try the case to one person being a judge.
Yeah, I understand.
Do you feel anyone has pressured you in any way to do this, to waive your right?
Yeah, I'm okay.
Okay. All right, accept the waiver. We'll just set it for trial. We've already discussed it pre-trial. There's been a ILC investigation regarding the matter. Get a date from Bethany. If you already have one, fine. Okay. Anything else from the state? Anything else, Mr. Elter?
No, Your Honor. Thank you for taking us in the middle of the trial.
Okay, that's all. Thank you.
Thank you.
We now return to our regularly scheduled broadcast.
Randy.
Sir, you've had a chance to look at what's been marked as State's Exhibits 2A through 2V. Is that right?
Yes.
And first, let me ask you, there's photographs that are screenshots of the videos and then photographs of yourself as well. Is that right?
Yes.
Depicting the injury you received.
Yes.
All the photographs you looked at, are they a fair and accurate depiction of what took place that day and then also the injury you received?
They are.
Okay. Thank you. All right, sir. Are you ready?
Yeah, you're good.
Okay, thank you.
You might just have to hit auto too. It's not clear.
I think that's good. Let me try. Sorry, Judge. Sometimes one paper is better and sometimes two papers better. Let's see how this works. I think that's too dark. All right, sir. This is State's Exhibit 2A. If you would just describe for the court what we're looking at here.
That is my initial approach to the defendant as I was instructing him to turn around to detain him.
And is this a screenshot essentially of the time when, even though you're telling him to turn around, he actually puts his hands up towards you?
Yes.
All right. She was marked as State's Exhibit number 2C. And sir, what does 2C show us?
The defendant still continued to, I guess, backpedal and not complying with my orders as I'm approaching to go hands-on.
Okay. Let me show you what's been marked as State's Exhibit number 2F. And what's 2F show?
That's me going hands-on, attempting to control his hands prior to trying to handcuff him.
Okay. So at this point, am I correct that by this time you've already made the determination that you were going to place him under arrest for obstructing official business?
Yes.
And again, you're trying to gained control and he is resisting and fighting against you.
Yes.
All right. Show us marked to State's Exhibit number 2G. And what does this picture depict as far as what your activity is?
That's myself, and now Officer Cooper is assisting with trying to detain him, and the defendant is actually lunging for grabbing on my gun.
So the last picture we looked at, we could see that you had your hands connected to both of his hands. Is that right?
Yes.
And in this picture, you've got both of your hands on his right shoulder. So is it fair to say that he is, between those two pictures, in that moment, he had actually been able to get freedom for his left hand, right? He got away from your grasp.
Correct.
And then if you look at the photograph, you see that he's looking directly at something.
Yes, looking down towards my right hip area.
Okay, and is your right hip area, is that where your firearm was?
It is.
And you can see his left arm grasping, or excuse me, moving towards an area. And what area is his left hand moving towards?
Towards my firearm.
Okay. Let me show us marked to State's Exhibit number 2H.
Okay, Mississippi's.
Now, is it fair to say this picture is actually a screenshot from Deputy Halsey's BWC?
Correct.
And in this video, or in this picture, excuse me, is this essentially a different angle of the same time, of the same activity?
Yes.
And so we can see him looking directly at your gun, right?
Yes.
And his left hand's actually, I'm sorry.
I'd rather you not tell him what
that's
we
fine.
can see. He's perfectly capable of saying what that represents to him.
That's no problem.
Okay.
We have permission
Okay,
for
so looking at the
Mississippi.
video from your experience that day, what is the defendant looking at?
My firearm, and actually his hand is on my firearm as well.
His left hand?
Yes.
Okay. Let me show you State's Exhibit number 2I. Is this just basically a closer picture of what we just described?
Yes, with the defendant, again, grabbing my firearm.
Okay. So let me show you what's been marked as State's Exhibit number 2J.
Brandy, is she having trouble hearing back there? If you would try to keep your voice up. It's not very good acoustics up there.
Your Honor.
Can you hear my voice back there? You have to turn it up probably. Can you hear my voice?
Oh, yeah, yes.
Okay. All right, go ahead.
Okay. Show us marked as State's Exhibit number 2J. And officer, tell us what 2J depicts.
So again, this is a still shot from a body-worn camera. Me going hands-on with the defendant, and he's actively grabbing my firearm.
My arm's on top of his arm. It's above his left hand, and you see the
what
other
is
one on
he
the right side. I'm sorry. I'm sorry.
And Judge, at this point, I know you've admonished him, but at some point, he's essentially testifying without testifying.
I know.
So, I ask you to admonish him to keep his mouth shut, please. Sir, From looking at this and your experience being there during that time, what does it appear that he's actually looking at?
That's my firearm, and again, he's grabbing the firearm as well.
Now, if you recall the earlier picture I showed you, it appeared that he was almost moving forward, almost falling forward in the first image we saw. Is that right?
Yes.
Now, in this image, am I correct that this is later in time than that first image?
Yes.
And does it appear that he's more upright now?
Yes, almost lunging forward to grab the firearm.
Okay. And again, was that moving against the force you were trying to push the other way against him?
Yes.
All right. Let me show you what's been marked as State's Exhibit.
Thank you very much.
2K for identification. Now, sir, again, if we move to Deputy Halsey's body camera at this point.
Yes.
And then what does this picture depict, sir?
With the defendant grabbing my firearm and holding it.
Okay. And am I correct that it appears he's moving against the force also being placed against him by Officer Cooper?
Yes.
Let me show you State's Exhibit 2L. And what does State's 2L depict, sir?
This is another, vantage point of the defendant grabbing my firearm.
And this is again from Deputy Halsey's body camera?
Correct.
All right. It was marked as State's Exhibit 2M. Is this a closer view of what we just saw?
Yes, sir.
Okay. And what do you see the defendant's left hand doing in that picture?
I'm grabbing my firearm.
All right. And when you say grabbing your firearm, am I correct from your early testimony? You said you not only felt a grab, but you felt a tug at your firearm.
A pull, yes.
Okay. And finally, State's 2N. If you would describe for the court what State's 2N depicts.
With me hands-on with the defendant, he's pulling my firearm and looking towards my firearm.
Okay. And sir, is it correct to say these are all fair and accurate screen captures of your body camera and Deputy Halsey's body camera?
They are.
Now, when you returned back to the police station after this incident occurred, did you take photographs to document the injury you received?
Yes, it's our policy to photograph officers injured.
Okay. And let me show you what's marked as State's Exhibit 2R. And let me turn it this way. And what is that, State's 2R, what does that depict, sir?
That is my right knee that I testified earlier about my injured when I fell to the concrete.
Okay. And then State's 2T. And sir, who's the individual in State's 2T?
That is Officer Cooper.
Okay. And you mentioned earlier that you were aware that his shoulder popped out of place during this incident. Is that right?
Correct.
Okay. And then what does this State's 2T depict?
He also said his right knee was injured during altercation.
Okay. And then State's 2U. Is that just a closer image of the injury to his knee?
Officer Cooper, yes.
Okay. Now, officer, when you had this experience you described with the defendant, from your observation, from the experience you had with him, and from what you saw and what you felt, did you have an opinion or a conclusion as to whether the grasping of your firearm, you described, was intentional or unintentional?
That he was intentionally trying to disarm me.
Okay. And that's the conclusion you drew from what you saw, what you felt, and the entire incident that occurred that day?
Correct.
And, sir, all this occurred in Warren County, Ohio, is that right?
Correct, yes.
All right. No further questions, Judge.
Thank you. Cross-examination.
Thank you, Your Honor. Officer, had you had any prior contact with Mr. Cole prior to that day?
I have not.
And your contact with him that day before physical contact was made was extremely brief, correct? From the time you got out of your vehicle until the time you attempted to arrest him?
Correct.
Okay,
yes.
we're talking seconds, really.
Correct.
Okay. No opportunity to have much of a conversation with him at all, correct?
At the moment, no.
Okay. You received information that came from Carlisle Police Department about this truck, correct?
Correct.
Okay. And how long was it from the time you received that information until the time you saw the truck itself?
If I had to guess, less than 10 minutes. It was
Okay.
relatively fresh.
Okay. What, if any, information were you provided about the situation?
Well, we are on the same radio channel as Carlisle Police Department, and I was aware that they were investigating a stolen vehicle complaint report. And again, with the information provided and the license plate provided, I ran it through the FLOT camera system to get an accurate picture of the vehicle to see if it will come to Springboro.
Okay. So you had a description of the vehicle, you had the license plate, and the vehicle itself was fairly distinctive, correct?
Yes.
An older model truck that kind of stood out in traffic? Okay. Did you have any information about the owner of the vehicle?
I believe they said it was his father's vehicle.
Okay. Okay. So you knew there was a family relationship of some sort at least?
His father's, yes.
Okay. Were you given any information regarding the mental health status of the defendant?
I was not, no.
Okay. Given any information on whether it was believed he had any weapons on him or anything like that?
Not to my knowledge, no.
Okay. But no indication that he had a weapon on him? Just no information?
I don't believe that was provided, no.
Okay. Okay. You see the vehicle pass you on 75. You pull out, you start following it, correct?
On 73, not on 75.
I apologize. Thank you. On 73?
Correct.
Okay. You followed into the Thorntons.
Yeah, I tried to stop it. Well, I stopped it.
Okay.
Thorntons.
Did you try to initiate a stop prior to him entering the parking lot of Thorntons?
I believe the lights were activated prior to pulling to Thorntons, yes.
Okay. So roughly about the same time as he was starting to pull in, you activated your lights?
Correct.
Okay. And he continues, and he pulls into Thorntons, so you pull him behind him then, correct?
Correct.
Okay. In addition to your body cam, you also had cruiser cam, correct?
Correct.
And that captured this as well?
It did.
Okay. All right, if we can get this set up, I want to play that part as well. Do I need to connect my laptop?
Good.
How do I do this?
You have like HDMI?
If I could have just a moment, Your Honor.
Okay.
Well, he takes a moment. I'm also taking a moment
And I
trying
have
to
the
get
same videos,
Top Mark
probably
Media set up
two
to
you have,
stream the Carly
flash drive as
Gregg
well. I'll mark
arguments.
these states A, 1 and 2.
Me defense.
I'm sorry. Defense A.
That's fine.
2.
Are they the body cams or the?
One's the body cam that you play, the other's the cruiser cam.
Okay.
that you play.
Gotcha.
HDMI port on yours.
Yeah. USB or HDMI?
HDMI is the easiest. And then it should make a sound once you connect.
We'll see.
It should
if
go
I can
ding
make this work.
when you connect.
I gotta switch it over before.
Okay.
Yep, it's connected.
And if you just put your USB in, you can just play like you normally do. You're good.
I'm sorry.
Oh, there you go.
Good.
Yep.
Okay, so let me, do you recognize this?
Yes,
Is this your cruiser cam?
appears to be, yes.
Okay. And this is you parked on 73 with 75 going across the overpass, correct?
Correct.
And then Thornton's would be off to the right side, am I correct?
Yes, to the east of this location, yes.
Okay.
I'm sorry about that.
I'll jump to about a minute.
That's all right.
It's not very long.
It's coming soon.
There, okay, we see the truck.
Vale Thornton's, the Carlisle stolen vehicle. John Kington, 5150.
Vehicle 21,
That was loud.
Okay, let me stop it there for a second. You pull your cruiser in, you're essentially blocking him in with your cruiser, correct?
I'm initiating a traffic stop.
Right. Your lights are activated at this time?
They are.
Okay, now he exits his vehicle, Mr. Cole does. Did you tell him to exit his vehicle?
I did not.
Okay. And then you immediately exit your vehicle and you're approaching him, correct?
Correct.
Okay. When you get close to him, he puts his hands up, correct?
Yes, order him to take his hands.
Hold, I know. Hold
I'm
on.
sorry, I can't hear.
You got to keep yourself under control here, okay?
Yes, he was ordered to take his hands out of his pockets.
I apologize.
He was ordered to take his hands out of his pockets.
Okay. Okay, so you told him to take his hands out of his pockets?
Yes.
And he did. He holds them up in front of you, so he's not holding anything, correct?
He pulled them out, yes.
Now.
Geared off unknown direct.
Let me back that up just a little bit here.
I was trying to
Okay. Now coming off from the right side of the screen, this is the recruit who was with you that day, correct?
Officer Cooper, correct.
Okay. Once you approached Mr. Cole, you were maintaining eye contact with him, correct?
Correct.
Okay. He's not looking around. He's focused on you. You're focused on him, correct?
Yes, I was watching the
Okay.
defendant, correct.
The other officer's coming around to his side, somewhat behind him. Is that your fair assumption there, or fair representation?
Appears so, yes.
Okay. He starts backing away from you, correct?
Correct.
And you're moving towards him. What's your concern at that point? Why are you going towards him?
He's in a freshly stolen vehicle, so I was trying to detain him for the investigation.
Okay. Is he making any sort of threatening move to you at this point, other than backing away from you?
I mean, he wasn't complying. I mean, as you can see on the video, I was telling him to turn around, put his hands behind his back, and he would not comply.
Okay, so you're telling him to turn around, put your hands behind your back, and he's just backing up instead, correct?
In a freshly stolen vehicle, correct.
False. I get to talk later?
Mr. Cole?
Okay.
Mr. Cole?
Yes, sir.
You can't talk while he's questioning the officer. You can't tell your attorney anything out loud. If you need to tap your attorney and say, I want to talk to you, you can whisper something to him.
Okay. As Mr. Cole is backing up, you're reaching out and you're grabbing onto his hands. We saw that in the body cam as well, correct?
Correct.
Okay. At one point, prosecutor asked you if he had his hands up in a fighting stance. Is that how you interpreted that? Was a fighting stance?
I mean, from my understanding, yes. When he first examined his pockets, yes.
Okay.
It's a defensive stance, correct.
He has his hands open in front of him, and he's backing up towards the truck as you're approaching him, correct?
Yes, as I was approaching him, took it as a defensive stance, correct.
His hands aren't in fists. He's not approaching you. He's backing away from you.
And not complying, correct.
At this point, you decide that you're taking him into custody, correct?
Correct.
He's still not responding to your instructions to put his hands behind his back and turn around, correct?
Yes, he still wasn't complying, correct.
Okay. So you decide to take him down at that point.
Well, no, I decided to detain him. It wasn't my intention to take him to the ground. My intention was to detain him. Once he started to fight, it was decided to take him to the ground.
He has his hands up. You have a hold of his hands. You release. You grab him by the shoulder, and you're taking him down to the ground.
After he failed to comply, correct.
Okay. As another officer is behind him and tackles him from behind. Correct?
Which officer are you referring to that tackled him? Okay, so you're grabbing him from the front, from his shoulder to pull him down. Another officer's kind of behind him and is pushing him towards you. And I believe at the time I was actually pushed him backwards. And actually at this still shot, you can see where his hand is grabbing my gun.
And then within a matter of seconds, he's on the ground. And at this point, there's 3 of you involved trying to get him down. Correct?
Correct.
Okay, so he's surrounded, there's people on all sides of him, and he's fallen down towards the ground. And that's when you feel him tugging on your weapon?
Incorrect.
When was that?
He pulled on the weapon as he's up on his feet. Then once he pulled on the gun, as I alerted the other officers, that's when we took him to the ground.
Okay, this is as he's going towards the ground, though, correct?
No, he's been pushed backwards, and he lunged forward to grab my gun.
Your gun was in a holster, correct?
Correct.
How do you normally carry your weapon? Do you have like a strap on it, or is it secured in any way?
It has a retention, yes, it's in a holster.
Okay. Was that in place?
I'm sorry?
Was that in place?
It's a feature,
Retention? Yes.
it's a feature
Yeah.
of the holster. Yeah. Just panicking, trying to get this live stream
And
set up for the
then-
top mark. Give me a minute. Almost there.
Within a minute of you exiting your vehicle, he's on the ground in custody, correct?
I don't know the exact time frame, but it's relatively quick. Correct.
Roughly a minute, minute and a half, somewhere in that time frame.
It's
Does that sound
pretty-
right?
It's pretty quick, correct.
Okay. Okay. You placed him under arrest at that point for obstructing, resisting, and attempted robbery of the weapon?
Correct.
Okay. You never charged him with unauthorized use, correct?
No, I believe Carlisle responded to the scene to custody of the vehicle, and they filed charges.
Okay. No further questions?
Redirect.
Also, let me show you States 2, Exhibit 2A. Again. This is a screenshot from your body camera, is that right?
Yes.
And is this the stance you were describing as being sort of a fighting stance that he took?
Yes, defensive fighting, yes.
Okay. And then that's when you reached out for him. Is that right?
Correct.
And am I correct, your testimony was that initially you were using your force to push him away from you?
Correct.
And that's when you felt the grabbing of your gun?
Correct.
From your experience that day, from what you observed and what took place, did him grabbing your gun have anything to do with him ultimately being taken to the ground?
Yes, I believe after he grabbed the gun, that's when I decided it's best to take him to the ground, try to detain him on the ground.
Let me ask it a different way, okay? From what you observed and what you experienced, do you believe he grabbed your gun intentionally or because he was falling to the ground?
I definitely believe it's intentional.
And he wasn't taken to the ground until after he grabbed your gun?
Correct.
And you said the gun was tugged, is that right?
Correct. It's pulled on, yes.
Did it, again, from your observation that day, from what you observed, what you felt, did it appear to you that the defendant was attempting to remove your weapon from his holster?
Yes.
And that action was intentional?
Yes.
All right. No further questions, Judge?
Recross.
The photograph we just saw, where Mr. Cole standing there with his hands like this, he was never just standing there like that, correct? I mean, that's one brief moment in this whole process, correct?
Correct.
So just because his hands were here at one point, this was a fluid motion where he was moving actively, correct?
Correct.
Nothing else.
All right. Officer, you're excused to go home and get some sleep if you choose.
Go get
just
some
don't
sleep.
discuss your testimony with anyone until the trial is over.
Thank you, Your Honor.
Even in your dreams.
Thank you, officer.
Sergeant.
Yes, Sergeant. I was about to do the same thing.
I said officer.
He's only been a sergeant for 3 days. He'll give you a pass.
Next witness, please.
Here are the state we call Deputy Halsey. All right, again. Thank you, Sergeant.
Okay, I think we're set up on the top mark side for the live stream. Audio's on.
into the ring.
Do raise your right hand. Do you solemnly swear that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
All right, sir, please tell us your name and spell your name.
Deputy Jacob Halsey, Jacobhalsey.
All right, sir. How are you employed?
I'm a deputy sheriff of the Warren County Sheriff's Office.
And how long have you been employed as a law enforcement officer?
Be 8 years in August.
And have you spent all 8 years working for the Warren County Sheriff's Department?
No, I started in 2018, and then I took a small year break. I went to the city of Monroe for a year, or just over a year, and then came back.
Okay. And so since that time, you've been working continuously, with the Warren County Sheriff's Office?
Yes, sir. I've been back since December.
Okay. And what are your duties as a sheriff's deputy?
I respond to calls for service and conduct proactive patrol and criminal interdiction.
Okay, so in the time that you've been back with the Sheriff's Department, you've been on road patrol?
Yes, sir.
Okay. And were you still employed on January 21st of 2026?
I was.
And on that day, did you have occasionally come into contact with an individual you later came to know as Charles Cole?
I did.
Do you see him in the courtroom today?
Yes, he's sitting in a green jail jumpsuit.
You're asked to record to reflect he's identified the defendant.
Granted.
Yes.
Just follow your
Now,
ears. He's the one jingling
what
like
was
Santa
it that
Claus.
caused you to have contact with Mr. Cole on January 21st of 2026?
Carlisle Police Department had a call for a unauthorized use of a motor vehicle. I don't remember exactly what was said over the radio, but we had reason to believe that he was going to be coming through Franklin. Also during that time, I was using Flock to try to track where the vehicle was, and I was 75 northbound. I was working a day shift that day, and as I was coming off on to the exit of State Route 73, I could see the truck because it was a pretty identifiable truck traveling eastbound on 73. Officer Scott was sitting just over by the underpass, and I saw the truck pass the Springboro police car. I saw Mr. Scott, or Officer Scott, pull behind him, and then I eventually made my way behind Officer Scott as he initiated a traffic stop on that vehicle as they were pulling into Thornton's.
Okay. And then when you see that stop begin to occur, what did you do?
I exited my vehicle at that point. Officer Scott got out, and there was another officer with him. I do not know his name. And the defendant had also gotten out of his car. I was decently far away, but it looked like Officer Scott was trying to effect an arrest and detain the defendant, and a scuffle ensued.
Now, as you were approaching, could you hear Officer Scott giving the defendant commands?
I could not recall him giving him commands.
Okay.
Not that I remember.
Okay. So once you got close enough to assist, what happened?
So I saw them lock up and Officer Scott trying to effect the arrest. So I ran up and kind of got in the mix with it. During that time, I do remember Officer Scott saying that he was trying to grab his gun. Eventually, we got him to the ground and eventually worked into where we could detain him.
Okay. Now, sir, were you wearing a body camera that day?
I was.
And was it working properly?
Yes.
And did it record your interaction with the defendant on January 21st, 2026?
It did.
Okay. And have you had chances to view what's been marked as State's Exhibit 1B?
I did.
And is that the footage from your body camera, of this incident?
It is.
Okay, I just got all the cables and connections done.
So at this point, I'd like to play State's Exhibit 1B, which is Deputy Halsey's body camera.
Yes.
While they're playing that, we now have permission to use the state of Mississippi live stream for the Gregg trial. It starts in 8 minutes. We have to grab it when it comes in. Would you rather continue this case, which we're not seeing the video on, or do you want to go hear the Carly thing for an hour?
Are you responding as you've described?
Yes, I can. I believe I'm at the red light at 70. The exit from 75 onto State Route 73, right here.
Now it's hard to see up on the screen, but to the right-hand side, we can see your mobile computer. Is that right?
Yeah, and there's that computer screen right there. That's Flock, which is what I was using to track the vehicle.
All right. And so the truck that you saw drive by, did that match not only the description, but the license plate of the truck that had been reported by Carla as a stolen motor vehicle?
So I couldn't see the license plate from where I was at, but yeah, it matched the description of the vehicle. And then Officer Scott got behind the vehicle and called it out as the unauthorized use.
Okay. Is that what we just heard? Is that the radio call by Officer Scott you were describing?
Yes. Call 21 now.
Unauthorized use vehicle coming red.
So, sir, at this point, as you described before, Deputy, you see Officer Scott and the defendant begin to actually have physical contact. Is that when you decided to take action?
Yes, that's. I was walking up. I was, letting Officer Scott. It was his stop.
I can't record this one as well. I'm recording too many things at once.
When I saw them, entangled, then I started to move a little bit quicker.
Okay. Now, sir, I've stopped this here. What we see here on the video, sir, is that your vantage point of what was taking place as
what
you
we don't
approached?
see.
Yes.
And are you able to see in this, where I've stopped the video, are you able to see the defendant's left hand?
Yes.
And where is his left hand?
On Officer Scott's firearm.
Okay.
I can't see it.
Hey, Mods, can you let me know if Top Mark Media is streaming properly, if it looks good?
You see in this image, the other officer, you don't know his name, but the other officer has a hold of the defendant. Is that right?
Yes.
All right, we're going to have to transition away from this. I apologize. We've been fighting all the paperwork things this morning, and I hate to leave a court halfway through, especially one with as jingly as this one. But we are not getting to see the video, which sort of sucks. And we did have a case that we followed, the Carly Gregg case, which we were very interested in. A teenager getting life without parole. That's a big deal. And we've got permission from the state of Mississippi, thanks to Beverly and some hurried paperwork, to be able to live stream their feed, which normally is not permitted. So thank you very much for that, for the Supreme Court of Mississippi for coming through in a big way that way. We're going to hear the arguments. This is an appeal hearing is what this is. She's appealing her conviction. I don't know exactly what argument she's going to make, but this is not going to be an argument where they say they shouldn't, the jury got it wrong. That's not this place. As a matter of fact, there's no place for that sort of argument in appeals, unless it was impossible for them to reach that verdict. But what we're going to hear is that something happened that was a mistake in the court system. Either the lawyer made a mistake, or the judge made a mistake, or errors were made where Carly was denied her rights to a fair trial, and because of that, she should get a new one. That's what they're asking for. And so we're going to be following this this hearing, which will only be an hour long. Each side gets 30 minutes. But if you remember this, Carly was 14 at the time. She grabbed a gun and held it behind her back. She's on video. Okay, there were cameras in the house, and she's on video with the gun behind her back, and she walks out of video, shoots her mom, and comes back. And it was cold. It appeared calculated, and then she calls a friend over. It's like, hey, come check this out. Come look what I did. So yeah, it's an interesting case. She got life without parole. For a 14-year-old, that's a strong sentence. That's really strong. But she was tried as an adult, and we think she's going to be there. So that is awesome. Feed looks good. Fingers crossed we've got audio and everything lined up correctly. Coming in from 3 to there. All right, it's all good. 30-minute seat. Yes. Is that crazy? Your whole life is in the balance. You get one shot at this with the Supreme Court, really, and you have 30 minutes to make all your arguments and answer all their questions. So a lot of the argument itself is made in a filing. There's a brief that's filed, and it's anything but brief usually. It's quite lengthy, but it contains the full argument. This oral argument is just a time to sort of highlight some of the notes and then answer questions that the justices may have. And I love hearing the Supreme Court oral arguments because the justices, they prove their value in the questions they ask. And it's fun to watch them. The best ones are able to switch, where they ask really hard questions from oh my goodness.
The Honorable Supreme Court of Mississippi, Justice King presiding. Oh yay, oh yay, oh yay. All persons having business before the court shall draw near and give their attention for the court is now in session. God save the United States, Mississippi, and this honorable court.
Okay, we're going to crank the volume all over the place to get this up.
You see that?
They just hit us with the microphone.
Clerk, would you sound the docket, please?
Oh yay, oh yay, oh yay.
2024 KA 1178 SCT Carly Madison Gregg versus the state of Mississippi.
What says the appellant? What says the state?
The state's ready to proceed, Your Honor.
Okay.
They're ready. They're not mic'd. They'll be mic'd at the podium.
Murphy, we'll hear from you.
20 minutes on the timer. It should be 30.
Good morning. Justices, may it please the court. My name is James Murphy, and it is my honor and it is my privilege to be here on behalf of Carly Madison Gregg. Here at co-counsel table with me is Lance Mixon, and we're both honored to be here as appellate counsel for Ms. Gregg. Now, this case is ultimately about whether a 14-year-old child received the fundamentally fair process the Constitution of the United States and the Constitution of the state of Mississippi requires before a juvenile can be sentenced to the most severe punishment, given the harshest sentence that the state of Mississippi can impose on a juvenile, and that is life without the possibility of parole.
Counselor, let me stop you there. I've read the sentencing order. The sentencing order in this case says that she's been sentenced to life imprisonment, which under the statute, and I think this is consistent with the argument you make on the sentencing issue, the statute, on subsection 2 of the sentencing statute for first-degree murder, gives two options. The jury can do life, can give life imprisonment, and if the jury doesn't, then the judge can assign a term of years. I don't know that I agree with you that this is a life without the possibility of parole sentence. The sentencing statute in subsection 3 seems to say there's life imprisonment. It doesn't seem to say, it does say there's life imprisonment, and then there's life without the possibility of parole or a term of years. So I'm reading this sentencing order, and to me, it's life imprisonment, not life without the possibility of parole. So why do you take the position that the sentencing order, what the sentencing order says is not what the sentence is?
Well, we would agree with Your Honor on that point, and if the state would concede that, I think we could make an easy argument of our sentencing argument here today. But I think the state's position is going to be that life sentence that was imposed by virtue of the parole statute imposes life without the possibility of parole. The jury in this case was given a sentencing instruction that gave them the option of sentencing Carly to life imprisonment or life with the possibility of parole. Now, by virtue of those two options, if they're not giving her life with the possibility of parole, by giving her life imprisonment, they are giving her life without parole. Those are just mutually exclusive options.
Well, I understand there's a separate parole statute in play here, and I can't remember the style of the case, but I know this court's issued an opinion that addresses the interplay between that parole statute and life sentences in other contexts. But just strictly speaking, or leaving the application of the parole statute out for a second, there are two options in that sentencing statute: life imprisonment and a term of years, and this sentencing order says a life imprisonment. So I don't see an inconsistency between the sentencing order or the legal sentences under the statute. And since that statute doesn't mention life without the possibility of parole as a legal sentence for this crime, I'm right where I am. I'm struggling to see why this is being interpreted as a life, other than the jury instruction, which admittedly doesn't match the sentence. But what we have in front of us, which is the order of the court sentencing Ms. Gregg, this is a life imprisonment sentence, which is consistent with the statute and doesn't seem to be without the possibility of parole.
Wow. And we would, yes, Your Honor, we would agree with Your Honor's interpretation of that. And again, if the state would concede that, we would certainly move on from that argument. But the state has argued in their response to our brief that by virtue of the parole statute, that life imprisonment judgment is in effect a life without the possibility of parole. And as I'm sure Your Honor and the court is aware, the legislature amended the first-degree murder sentencing statute 97-321, amended that statute effective July 1st, 2024, and added a juvenile-specific sentencing structure for both first-degree murder and capital murder. And subsection 2C, which deals with capital murder for juvenile convicted of capital murder after July 1st, 2024, it gives the jury two options, as I think Your Honor would concede. It gives the jury the option of sentencing a convicted juvenile to either life imprisonment or life without the possibility of parole. However, subsection 2B omits that option and only gives the jury the one option of life imprisonment. And I think that goes along with what Your Honor is saying. The first-degree murder sentencing options for a jury in a juvenile case only gives the jury the option of sentencing a juvenile to life. And by virtue of the legislature defining life without, or including life without parole in subsection 2C, and not defining life as life with parole, the only other option is that life imprisonment means life with the possibility of parole. So we would concede, Your Honor, that is the case. In fact, if the court interprets the amendments that way, we would concede that argument.
He's put in the court.
But from March 19th, 2024,
and the state
when the incident
notice.
occurred, until the verdict and sentencing order were rendered on September 20th of 2024, this entire case, the entire case, from investigation to indictment to psychiatric litigation to motions filed to motions argued to expert evaluations to discovery to trial to sentencing, it proceeded in approximately 6 months, 183 days to be precise. In a medically and psychotropic medication evidence and dissociation case of this nature, that pace was extraordinary. And the accelerated pace of the proceedings affected virtually every aspect and major issue now before this court. And my first issue I was going to begin with was the sentencing issue, but as the court, I think we've discussed that. If there are any additional questions about that, we would argue certainly that the amended statute does not give a jury the option of sentencing a juvenile convicted of first-degree murder after July 1st, 2024. We would argue that the new amendments do not give a jury the option of sentencing, nor does a judge have the option of sentencing a juvenile convicted of first-degree murder, does not give them the option of sentencing her to life without parole. Now I will transition to the Miller issues. Again, we would argue that the new amendments, they pretty much make Miller obsolete in the context of sentencing a juvenile after the amendments. But assuming that the Miller progeny of cases is still in effect and is still the controlling law when it comes to determining what's proper sentence for a juvenile convicted of first-degree murder, we would propose that the the Miller framework was not met in this case. The Miller requires individualized sentencing before a child may be condemned to die in prison. And again, we're operating under the assumption that the state's position is that Carly Gregg was sentenced to life without the possibility of parole. The proceedings here never became the careful, individualized juvenile sentencing hearing contemplated by Miller. The sentencing phase of this case, and again, this case went from the occurrence of the event on March 19, 2024 to the trial on September 16th, concluding on September the 20th of 2024. The sentencing phase, and I'm going to use that term loosely, the sentencing phase of this case consisted of the court announcing the verdict of the jury and then transitioning immediately to asking the state whether they wanted to call their first sentencing witness, to which the state responded that they basically wanted to rest on the evidence that had been previously presented and proceed with argument only. And the defense did the same thing. The defense elected to rest on the evidence that had been previously presented and proceed with argument only. Now, we would argue that this immediate pivot from the announcement of the verdict to the sentencing phase was wholly inadequate in light of Miller. There was no meaningful mitigation development process. There was no opportunity given to the defense to marshal mitigation witnesses. They were given no opportunity to call witnesses, family members, teachers, and as a matter of fact, as part of the pretrial process, the defense listed as one of the potential witnesses the grandmother of Carly Gregg, Miss Vicki Breland, who also happened to be the mother of one of the victims, Ashley Smiley. She was listed as a potential witness, and she was not allowed to testify at the trial, so it stands to reason if she was not allowed to testify at trial, then the question then becomes, would she have been allowed to testify during the sentencing phase? And again, I use that term loosely because there was no meaningful opportunity to conduct a Miller-compliant sentencing hearing. There was no PSI, pre-sentencing investigation conducted, no report. The jury was exposed to confusing and inconsistent parole rhetoric by the prosecution at one point. And again, I'm going back to the sentencing hearing, which consisted of, and it's confusing, the record is confusing as to whether each side was given 7.5 minutes, 15 minutes total for their sentencing argument, or whether they were each given 15 minutes. At one point, it looks like the judge gave one side 7.5 minutes, and then the other side was given 15 minutes. So it's not clear to me from the record whether they were given 7.5 minutes to argue the sentencing phase or 15 minutes to argue the sentencing phase. But at one point during the state's argument during the sentencing phase, the state told the jury that if you give her, and again, this is going to the sentencing instruction that they were given the option of life or life with the possibility of parole. The prosecutor stood in front of the jury and told them that if you give her life with the possibility of parole, we don't know when she's going to get out. She might be out, and I'm paraphrasing here, she may be out in as little as a year, which I think we all know is outside the realm of possibility for a life sentence. But she may be out in as little as a year, and again, I'm paraphrasing, but you may see her at the supermarket, or you may see her at church. You may run into her at any place outside in public, and again, we would argue, and we argued in our brief, that is improper golden rule rhetoric. It's appealing to the fears of the community, and that is improper. And I understand the state's going to argue and has argued in their brief that the defense failed to object to this, but notwithstanding that failure, we would ask this court to analyze that under the plain error doctrine and or pursuant to the ineffective assistance of counsel claims that we've made in our brief. We can see no strategic reason why a competent defense counsel would not object to that type of rhetoric argued in a sentencing phase. And in addition, even taking into consideration if the Miller progeny of cases is still the law and still applicable to juvenile first-degree murder and capital murder cases, the record is replete with examples of why there were mitigating factors. And we would submit that the juries, and again, assuming they sentenced her, they elected to sentence her to life without parole. And by the way, let me back up, I digress just a little bit. After the the prosecution's statements about parole eligibility and when she might be out within a year, and you might run into her at the supermarket, after the jury began their deliberations, almost immediately after they begin their deliberations, we know that parole was on their mind and how long she's going to spend in jail if she gets granted parole eligibility, because they submitted a question, and I'm going to paraphrase this too. If Carly is granted parole eligibility, if she's given life with the possibility of parole, which is one of the two options she was given by the court, if she's given life with the possibility of parole, how long will she serve years-wise? So we know that was on their mind. We absolutely know that was a question that they had in their mind going into deliberations. Nothing minimizes the horror of what happened to Ashley Smiley or the trauma suffered by Heath Smiley. Nothing minimizes that. But Miller requires courts to distinguish between irreparable corruption, incorrigible youth, and transient immaturity before condemning a child to die in prison. And again, assuming that the state's position is correct, that she was sentenced to life without possibility of parole, that is exactly what she was done. She was sentenced to die in prison, because if she's not eligible for parole at any point, then she will pass away in prison, and that's in effect a death sentence. And I want to read
Mr. Murphy,
from a brief.
Mr. Murphy,
Yes,
let me
Your
just interrupt you there for a second. I want to clarify something for purposes of I know this court has written that for purposes of the application of that parole statute, the one that forbids parole for people guilty of first-degree murder, we have held in the Miller context that is the same as a life imprisonment. So, but you've still got, I think you conceded, not just as to those comments that were made by the prosecutor, but also as to the hearing itself and the brevity of the hearing, et cetera. There were no objections made by defense counsel.
Ineffective assistance
that
of
would
counsel.
preserve that issue for appeal, were there?
No, Your Honor, there were no objections. And as to that issue, Your Honor, a case that we cited in our brief, Presley v. State, which is 474 Southern 2nd 612.
This is plain error.
A case
Doesn't
that
need to
was
be
decided
objected
by
to.
this court in 1985, a case where the sentence was vacated. And in that case, a pre-sentence investigation report had been prepared and submitted to the court. The trial court offered defense counsel the same as apparently the trial court did in this case, gave defense counsel the opportunity to present mitigation, and defense counsel nevertheless failed to meaningfully develop mitigation evidence. And the court in that case vacated that sentence based on the rationale and the holding that, and I'm going to quote from the Presley court, "We recognize that there are cases even where the appellant and his attorney fail to prepare and complete a sentencing record, as was done in this case, or not done as the case may be, where the trial court must consider all facets, background, and record in a sentencing hearing in order that a just and proper sentence may be imposed." So we would submit to Your Honors that this court has the power to impose that duty on the trial court, just as it would impose the duty on the defense counsel. And even barring that plain error submission that we are offering here today to give the court the authority to review that, again, I think we've offered the Strickland v. Washington ineffective assistance of counsel claim. We can fathom no strategic reason why defense counsel would not want to ask for time.
Is this court in a position on this record to evaluate the prejudice prong of Strickland, not knowing what mitigation evidence might have been discovered had that work been allowed to proceed?
I believe that we could evaluate the prejudice prong based on what we know about what had been presented earlier in the case. We had two forensic psychiatrists who testified in this case. And I believe even the state's forensic psychiatrist opined that Carly was not a psychopath, that she was not evil, and that she came close, and I'm paraphrasing here, that she came close to the evaluation needed to reach the McNaughton standard. Even the state's own psychiatrist stated as such. And then you had the defense psychiatrist who found that she did meet the McNaughton standard. So the failure of the defense counsel to at least recall those witnesses to testify in the context of a sentencing phase would clearly be prejudicial. To bring out those points that they had made earlier in the proceedings to specifically apply to the sentencing phase, I believe that's absolutely prejudicial, Your Honor. In addition, the issues that I brought up earlier, the witnesses, the lay witnesses that could have been marshaled and provided, the family members that I believe are here today and that were prepared to testify on behalf of Carly in the sentencing phase, teachers, friends, all of those things, as far as we are aware and as far as the record reflects, they would have all testified on behalf of Carly and would have provided positive mitigation evidence on her behalf. So yes, Your Honor, we would submit that the record is sufficient to evaluate the prejudice prong of the Strickland analysis. Now, outside of the sentencing issues that we've discussed, Your Honor, the trial court announced at the very first interaction between the trial court and the litigants in this case, announced not once, but twice, that this court does not continue cases. And it even mentioned that y'all have heard me say this before today, that this court does not continue cases. Now that posture shaped the atmosphere of the litigation from the very beginning. Now you may ask, is that in and of itself, is that an abuse of discretion? And we would offer, and we cited Leonard v. Leonard, where a discussion was had of whether a court can issue blanket denials of continuances, and that court held that it is abuse of discretion to prejudge and pre-rule that there are no continuances allowed under any circumstances. And that we would submit that is exactly what the trial court did in this case, announced from the outset that there are no continuances going to be granted. Now the state offered in their response brief that this was not a blanket denial of continuances. This was just an attempt by the trial court to prevent dilatory tactics of the litigants. But Your Honor, looking at the four corners of the transcript,
10 seconds.
We saw no caveats issued. There were no continuances unless so-and-so happens. No continuances unless there's a darn good reason. There was none of that. It was a blanket denial of continuances. Well, then the state's going to submit to the court. Well, the defense never asked for a continuance. So there's no harm, no foul. It's harmless error. Even if it's error for the court to issue a blanket denial of continuances, that error is harmless. But to that, Your Honor, we would offer a plethora of cases, including Mississippi Rule of Evidence 103C, that says no further objection or offer of proof is required where the court's ruling is definitive. Smith v. State, which we cited, 724 Southern 2nd 280, preservation rules do not require actions that would serve no practical purpose.
Mr. Murphy.
Time.
Without any motion being filed, exactly what do we have in the record where we could say that it was an abuse of discretion not to grant a motion for continuance?
Well, it was not necessarily an abuse of discretion to not grant a motion for continuance because obviously, as we would concede, there were no motions for continuance.
But I mean, are there any reasons for a continuance? I haven't even heard you argue whether there were any reasons for a continuance that were considered, contemplated, and not requested. You're just simply asking, as a statement of law, for us to find the trial judge in error because he made a statement.
Well, Your Honor, and again, going back to this line of cases that basically says a litigant, a defense attorney, or any attorney is not required to ask for something he knows he's not going to get in order to preserve error. That's exactly what Mississippi Rule of Evidence 103C says. Further objection or offer of proof required where the court's ruling is definitive. There is no requirement.
Counselor, further objection seems to indicate that there was an objection initially. So I think those cases that you're citing, in those cases and the text of that rule, still seem to require an initial objection or motion that is denied. I know that Leonard versus Leonard, there was a motion that was denied. That's what the court was reviewing for error, was the decision. So, I mean.
And I think the rules of civil, at least the rules of civil procedure, required that any request made to the court be made by motion. written motion before trial or during trial and oral motion. And so even, I hear your argument, but I don't hear you saying any reason why this was error.
Well, Your Honor, it was error because number one, it chilled the litigants. They
got a chilling effect.
I hate to say afraid perhaps, but and going back to Smith versus State,
I'm not sure anybody was chilled in this case. Just reading the transcript, it seems to me that there was very active participation in this case by the lawyers. And certainly there's no reason a motion couldn't have been made, but I'm just wondering, give me some basis for the continuance.
Well, Your Honor, and this is getting into the orders for psychiatric evaluation, which we think were premature and beyond the scopes of Mississippi Rules of Criminal Procedure. The litigants, they were very active, Your Honor. It appears that they were bending over backwards to abide by the court's, for lack of, and I put it in my brief, so I'm going to say it here today, rocket docket. Announced that this trial is set for trial September 16th, and there's absolutely no reason that we see that this trial can't go forward. So everybody was bending over backwards to accommodate that trial schedule.
As they should, though, isn't it? I mean, that's what we want is a speedy trial. We have so many cases come through here where it's delayed and delayed and delayed, and now we have one that's moving quickly through the system, which is supposedly the way it's supposed to work, and there's no basis in the record to say a continuance should have been granted.
Well, it was continuing in a speedy fashion at the expense of Carly's constitutional rights. The trial court ordered her to undergo competency and insanity at the time of offense evaluations before the 17.4 threshold of announcing the insanity defense had been met. And that is simply not what the rules contemplate. And in fact, the defense attorneys in this case filed a petition for interlocutory appeal to appeal that ruling. Her constitutional rights were we would submit, trampled on because they were ordered to turn over privileged information, medical records that they would not have otherwise have had to turn over to the state, but for the insanity defense, which at the time they were ordered to be turned over, had not been properly put before the court. Sure, the defense counsel at one point said that we intend to assert an insanity defense, but with all due respect to all of the attorneys that were involved in this case and even the trial court, none of us are psychiatric or forensic psychiatrists. And so for me as a defense attorney to announce at the beginning of a case before my client has even been evaluated by a forensic psychiatrist, and for me as a defense attorney to say we're going to assert the insanity defense, I believe is malpractice. Because I don't know what an evaluator is going to say once that evaluator reviews all the records and interviews Carly and makes a determination as to whether she has met the Minalton standard. So they were given a Hobson's choice to either turn over those records and waive the privileges that go along with turning over those records, or waive the defense altogether, and they chose to preserve that defense. And until and unless they file the 17.4 notice of insanity defense, the court does not have the power
to compel those documents.
The court does not have the power to order Carly to undergo psychiatric evaluations at the behest of the state. The court...
Does that apply? Okay, so the state made a motion, as I recall. Correct me if I'm wrong on this, because there's a lot going on in this record.
Yes, Your Honor.
And the court granted the state's motion and sent Ms. Gregg for evaluation, both as to competence to stand trial and the McNaughton issue.
Correct, Your Honor.
But the psychiatrist, counselor, I don't remember which, to whom the court sent Ms. Gregg for that evaluation, reached an opinion as to competency to stand trial, but declined to issue an opinion on McNaughton. Is that correct?
The initial state's expert, yes, that is correct.
All right. Does the fact that that expert declined to address McNaughton or issue an opinion on that affect your argument that it was wrong to send her for that evaluation?
Only reason she declined to render an opinion was because there were some issues with marijuana or some other...
Whatever the reasons were.
Right.
Does that affect your argument that it was incorrect for the trial judge to order?
It absolutely does not affect my argument. That was premature and that was incorrect and outside the court's power to order that exam at that point in time.
And you're saying that the harm that resulted from that is that it gave the defense's strategy up too soon and forced the defense to disclose documents it wouldn't have otherwise yet disclosed?
Among other things, yes, Your Honor.
But those documents would have been disclosed because the defense did pursue the insanity defense.
Yes, Your Honor. If the defense had ultimately chose to pursue the defense of insanity, those documents would have been produced. But if the rules had worked the way they're supposed to have, and the timing had worked the way the rules require, then the defense would have had Carly evaluated by their expert, who would have reviewed all those records and interviewed Carly and made a determination, yes, she qualifies for the McNaughton insanity defense, then you hand it all over. But if that, in contrast, if that evaluator and that expert had said, no, she does not qualify, then the state does not get the benefit of those privileged documents. The state does not get to have their expert evaluate her. So by jumping ahead and then ordering that the state gets to evaluate her ahead of time, it inverts the whole process. It gives the state access to documents that they may not have otherwise had access to. And with those privileged documents, of course, come waivers of communications that Carly had with her treating physicians and psychiatrists and counselors, among other things. And I think everyone would recognize, I think that we'd ask the court to take judicial notice that each evaluation of somebody would affect the next evaluation. And by virtue of the state having the first, I believe the state had the first opportunity to evaluate Carly because the defense's first expert was taking more time to evaluate her than was initially anticipated. And going back to that, they certainly weren't outside of their time limit. According to Rule 17.4, the defense has until the time for filing pretrial motions to assert the insanity defense. And in this case, the court's pretrial motions deadline was August 30th of 2024. The court started pressuring the reports back in June or July of that summer, well before the pretrial motions deadline of August 30th. So the court entered the order July 3rd that she submit to a state expert evaluation.
Okay, Mr. Murphy. Are there any other questions of Mr. Murphy at this time? Okay.
All right, switch sides.
Thank you, Mr. Murphy.
Thank you.
State's going to get up. They're going to talk a little bit about
the court will hear from you
life without
this
parole.
time.
See if they concede that point.
Mr. Murphy took an additional 9 minutes on his primary presentation, so if need be, the court will also extend additional time to you.
Thank you, Your Honor. May it please the court. Good morning. My name is Allison Hartman. I represent the state of Mississippi on behalf of Attorney General Lynn Fitch. This court should affirm Carly Gregg's first-degree murder and attempted first-degree murder convictions and her life imprisonment sentences because every aspect of her trial was fair and no errors were committed in the trial court. Gregg raised several issues related to both the guilt and penalty phases of her trial. Most of those claims are waived because she failed to contemporaneously object or otherwise raise those issues in the trial court. But even if we set the waiver bar aside, all of her claims lack merit and should be denied. I'd like to start with the penalty phase issues because it seemed like that was what the majority of opposing counsel's argument focused on, and then circle back to the guilt phase issues as time and interest allow. It's critical to establish at the outset that Gregg's sentence for first-degree murder is life without the possibility of parole, and her life imprisonment sentence for attempted first-degree murder.
Where do you see in the record that that's her sentence?
Your Honor, we have to look to the parole statute and the sentencing statute.
I understand that the parole statute prohibits parole for somebody who's been sentenced to life. And I understand we have cases that say essentially that means every sentence is life without the possibility of parole in effect. But there's an issue in this case regarding a jury instruction and regarding an illegal sentence. And because of that, I think it's important to see, separate from the application of the parole statute for a minute, what she was actually sentenced to.
So
and the sentencing statute in this case allows for 2 sentences, life in prison if that's set by the jury, and a term of years. All right, so the sentencing the sentencing order in this case sentences her to life imprisonment. So absent the application of a parole statute, which itself could be amended by the legislature any minute, I don't understand, I mean, I get why you say the effect of her sentence is life without the possibility of parole, and I think that's relevant to the Miller discussion. But to the illegal sentence and the jury instruction issue, I think it's relevant what that sentencing order says. So what the sentence, you will agree with me, the sentencing order says life imprisonment.
Yes, Your Honor, it
And
does.
you will agree with me that that is one of the legal sentences under the sentencing statute.
Yes, Your Honor. So the legal sentence under the statute, the amended statute, like you mentioned, is life imprisonment.
And if the legislature were to amend the parole statute in this next session, I don't have any reason to think they would, but if they did, and they were to remove the language that says you're no longer eligible for, the language that says you're not eligible for parole if you're convicted of first-degree murder, that's what relevates this effectively to a life sentence we've held. Then all of a sudden she's no longer sentenced to life without possibility of parole. Is that correct?
I think, yes, Your Honor, because that's what the court did in Johnson versus State. That was this court. Johnson was originally convicted in 2000, which was pre-Miller, and he was sentenced to life without the possibility of parole, which was under the essentially mandatory life imprisonment without parole sentence pre-Miller. And he successfully filed for PCR, and he received a resentencing hearing in the trial court, and the trial court conducted the Miller hearing, considered the Miller factors, and again sentenced him to life without the life imprisonment. And then this court interpreted that life imprisonment language, which is identical to what we have here, and it considered the parole statute and said that you have to read the sentencing statute and the parole statute to understand what the life imprisonment statute or what the life imprisonment sentence actually is. And that when you consider those two statutes in tandem, essentially under the amended sentencing statute, life imprisonment is life without the possibility of parole. And I think that the court can just look to its own decision in Johnson versus State, which is really instructive on this issue because it's one of the only cases that actually interpret the amended sentencing statute that went into effect in July of 2024. And this court recognized there that you have to read the sentencing statute and the parole statute in tandem to give effect to what life imprisonment actually means. Because as Your Honor mentioned, life imprisonment is the maximum penalty under the sentencing statute. And you have to look to parole eligibility statute to determine what life imprisonment actually means.
In Parker v. State, we held that there should be a determination when that parole statute is in play. It's awkwardly worded, I think, but we said, let me find it, whether or not the defendant should be sentenced to a term of life imprisonment with eligibility for parole, notwithstanding the parole statute. Was there any attempt to instruct the jury on that or to raise Parker before the trial court to try to get a determination that the life sentence should be, notwithstanding the parole statute?
I'm sorry, are you asking whether the trial court should have...
I'm asking whether or not there was an attempt made to follow Parker v. State in the trial court. If you're going to sentence Ms. Gregg to life without the possibility of parole and claim that it's because the parole statute, forbids parole, in Parker we said there needs to be a determination of whether or not that sentence should be life with the possibility of parole, notwithstanding the parole statute. Mm-hmm. I'm asking you if that procedure that was laid out in Parker was followed in this case.
It was, Your Honor. At the sentencing jury instructions conference, the court and the parties were discussing the sentencing instructions, and there the court was looking at the state's proposed instructions and the defense's proposed instructions. And the court and the parties both acknowledged that under Miller there had to be a Miller compliant hearing, but also that under Mississippi's sentencing statute as amended, life imprisonment meant life without the possibility of parole. So all the parties recognized that under that first sentencing option in the instruction, life imprisonment was effectively a life without parole sentence.
That's effectively true, but that leads us back to the problem with the jury instruction, which is life without the possibility of parole is itself not a sentence, a legal sentence under the sentencing statute to apply to a juvenile for first-degree murder. It's not listed in the statute, correct?
Yes, you're right. I mean, the plain language of the sentencing statute doesn't say life without the possibility of parole. It just says life imprisonment.
And so that jury instruction led the jury to believe, I mean, it just didn't follow the sentencing statute because it instructed the jury life without the possibility of parole or life sentence, which in the jury's mind, a life sentence meant, I guess, what, a life sentence with the possibility of parole, but that's not what the statute provides. In the statute, if you look at the two subsections together, in particular, it's pretty clear that a life sentence means, under the statute, life with the possibility of parole. So
I would disagree with that reading of the statute, because I think you still do have to read the statute with the parole statute in tandem. I know that you're hesitant to concede that point, and I understand, but this court has held time and time again that the parole statute and the sentencing statute have to be read in tandem.
okay, and I might disagree with that, because, again, what happens, we've sentenced a few people in this state to life without the possibility of parole because of the parole statute. What happens to the legislature? The legislature has in the past, has reformed the parole procedures and the parole, what if the legislature changes that statute and removes that language and all of a sudden makes people who are guilty or found guilty of first-degree murder eligible for parole? We have to go back and re-sentence everybody that was sentenced to life without the possibility of parole because we read the sentencing statute in tandem with the parole statute?
No, I think Johnson, this court's decision in Johnson versus State indicates that it's the statute that's in play at the time of sentencing. Because even though Johnson was sentenced in 2000, he was re-sentenced.
The sentencing statute?
Yes.
The parole statute is not a sentencing statute. The parole statute is a prohibition on parole.
Right. But in Johnson, this court also considered the parole statute that was in effect at the time that Johnson was re-sentenced.
Is that the court rewriting a parole statute as a sentencing statute when the legislature clearly intended to govern parole?
I don't think so, Your Honor. I think it's just interpreting what life imprisonment within the sentencing statute actually means. Because in order to determine what life imprisonment means, again, you have to consider parole eligibility. And to do that, you have to look at the parole statute. So the only way to interpret life imprisonment is to look at the parole statute to determine whether or not there is parole eligibility under that statute.
So, Counselor, how do you rectify the fact that one section of the statute says life and the other section says life without parole? Why bother delineating those two sentences in the statute if we're just going to pretend that there's no distinction between them?
I agree, Your Honor, that it's interesting that the capital murder provision and the first-degree murder provision are stated differently in the statute.
Do you think maybe that's because the legislature intended them to be handled differently in reality, in the world, in life, in court?
Possibly, Your Honor, but there is a distinct difference between capital murder and first-degree murder. We tend to look at capital murder as more severe, but first-degree murder requires deliberate design, intent, premeditation. Capital murder doesn't require that. It could
You can be convicted of capital murder without actually murdering anyone.
That's right. So
why do we make that distinction where somebody who does something that's not even as bad as murder or killing someone gets life without parole, and it's delineated in the statute, life without parole, but now you're standing here saying, oh, well, just ignore the fact that the section right above it just says life and doesn't add without parole. That's disingenuous, Counselor.
No, Your Honor, I'm not trying to say ignore that. I'm trying to point out the difference between the two provisions. And the capital murder portion of the sentencing statute also provides for the option of life with the possibility of parole, where the first-degree murder sentencing provision doesn't provide for the life with the possibility of parole. So I think there is an intentional difference there in creating an avenue for parole eligibility within the sentencing statute for capital murder.
But you're treating them the same. That's my point. Thank you.
Yes, but Your Honors, I think that if this court looks to Johnson versus State, it's very instructive on how this court should deal with this issue here today. Because there, again, the court dealt with this exact sentencing statute and the parole statute. It read them in tandem, and this court said that under the sentencing statute, the language, life imprisonment, under subsection 2B, which is the subsection we're operating under, life imprisonment means without parole when you give the parole statute consideration. And that's what this court said, is that you have to consider the parole statute, and that once you consider the parole statute, life imprisonment in subsection 2B is without parole. And that's how, in this case, we know that Carly Gregg's life imprisonment sentence is without parole, and it's not with the possibility of parole. And kind of going hand in hand with that, Carly Gregg's jury had the discretion to impose a life imprisonment sentence, or if it couldn't reach that, then let the judge decide the penalty. And that's consistent with the United States Supreme Court's holding in Miller, which required an individualized sentencing hearing, after which the jury or the sentencer considers the Miller factors before imposing a life in prison sentence. And neither the Supreme Court nor this court have ever laid out step by step exactly how a Miller hearing is supposed to be conducted. If you look to Montgomery versus Louisiana, for example, or Chandler versus State in this court, or McGilberry, the Supreme Court and this court both say that the defendant has to have an opportunity to present evidence to support the Miller factors, and that the jury or the sentencer, because it could be the trial court in certain circumstances, consider the youth and its attendant characteristics using the Miller factors. And that's what happened here. Gregg had the opportunity to present evidence on the Miller factors, and her defense trial strategy was to focus on allowing the judge to sentence her instead of the jury, because the sentencing authority of the judge was only 20 to 40 years. So I think her trial strategy was clear, to hope that the judge would sentence her and not the jury, so that she could get a lesser sentence. But the jury instruction, SS1, which is at the clerk's papers 1093 to 1094, it lays out the Miller standard clearly, and it says it instructs the jury what the Miller factors are, and it instructs the jury to consider those factors in determining whether or not it should sentence Gregg to life imprisonment. And that, in effect, was the Miller hearing. Just because Gregg now says that she wished she presented more evidence doesn't mean she didn't receive everything that she was entitled to under Miller, which was a separate individualized sentencing hearing, and the jury considered the Miller factors and exercised its discretion to impose life imprisonment instead of letting the judge decide her punishment. And I think, circling back a little bit, I think on the jury instruction issue, it's also crucial to recognize that Gregg not only didn't object to the state's proposed jury instruction, which is SS1, but she actually withdrew her own proposed instructions and acquiesced to the state's instructions. So I think that goes beyond waiver, and the fact that Gregg agreed to those sentencing instructions, and now she can't come back on appeal and claim that the trial court erred in giving those instructions because she agreed to them. As I mentioned, Gregg received everything she was entitled to under Miller. That individualized sentencing hearing, the jury considered the Miller factors, and the state presented sufficient evidence on each of the Miller factors to support the jury's verdict. It submitted evidence on her chronological age and how her maturity level, education level, ability to maintain relationships overcame her young age, which was 14. Her family and home environment. She had a tough upbringing in the beginning, but once she moved out from her biological dad's house, for all intents and purposes, she had a great home life. Her parents supported her hobbies. They took her to guitar lessons, karate. They supported her academic success, and most notably, when she expressed any issue with her mental health, they immediately took her to get psychiatric and therapeutic help. And then the other Miller factors, the circumstances of the homicide offense. Obviously, the jury here heard significant evidence about the horrific nature of the murder. It heard and saw photos where Gregg shot her mom 3 times, point-blank range in the face. So obviously, that the circumstances of the homicide offense weighed in favor of the life imprisonment sentence. So this court should affirm her sentences because she had a Miller-compliant hearing, the jury instructions adequately tracked the statute, and the state submitted sufficient evidence to support the imposition of the life in prison sentence. And I also want to briefly touch on Gregg's claim regarding the prosecutorial misconduct.
Let me ask you to back up. Your comment about the jury instruction adequately tracked the statute, and I hate to keep coming back to this, but the statute, when you say the statute, the sentencing statute does not have an option for life without the possibility of parole.
Yes.
It does not have that possibility.
That's right.
So when we're in a situation because of a case from this court, the Johnson case, the cases where we've basically held that effectively every life sentence is without the possibility of parole, so we might as well go ahead and sentence them to that. But we're in a situation where we're trying to work with that precedent from this court can even make the argument plausible that a jury instruction that flat does not track the language of the sentencing statute itself tracks the language or tracks the law. Doesn't that seem like a problem for you, where we can't actually track the sentencing statute that the legislature chose, which, by the way, these amendments took place after Johnson. They took place after Miller.
Yes, Your Honor.
That doesn't seem like a problem to you, that we have to actually not track the statute to track the statute?
Well, I think the sentencing instruction did track the statute, and that it said life imprisonment was the option, not life without the possibility of parole. So it didn't actually, the sentencing instructions didn't actually say life without the possibility of parole. It just said life imprisonment, and that's what the jury sentenced Gregg to. Then we know that's without parole because, again, going back to the parole statute, which says that first-degree murder is not a parole-eligible conviction. So technically, Your Honor, the instruction did track the statute, especially when you consider the parole portion of the statute. If Your Honors don't have any more questions about the penalty phase of Gregg's trial, I'll move on to the couple issues that opposing counsel raised regarding the guilt phase. First, in regard to Gregg's argument that the trial court prospectively denied all motions for continuance, I think that's a stretch to say that the trial court expressly denied any motion for continuance. This was during a status conference where the parties were discussing deadlines and how the case was scheduled in terms of proceeding forward, and the court just expressed his general dislike for continuing cases. But it's critical in this case that Gregg never moved for a continuance. She never sought more time. She never indicated that she needed more time to do anything. So there was nothing really right for this court to consider because there was no denial of any motion. So we would just argue that she waived that claim and that there's no decision for this court even to review in regards to the, quote, prospective denial of motions for continuance. Turning to the Monotone issue, really Gregg argues form over substance here, because the truth of the matter is that from the beginning of the pretrial hearings, the scheduling conferences, status conferences, she repeatedly indicated that she intended to pursue the insanity defense. We cited in our brief a thorough account of all of the instances where she expressed her intent to pursue an insanity defense to the trial court, and we would also refute her contention that the state had the first chance to have her evaluated. It was the court who appointed Dr. Gugliano originally to evaluate Gregg for both competence to stand trial and monotone insanity. And as Your Honor recognized earlier, Dr. Gugliano did not feel comfortable proceeding in doing a monotone evaluation based on the fact that Gregg was on some drugs and that there was some medication history in regards to what she was prescribed. So after that, Gregg hired her own expert, which was Dr. Webb, to conduct her evaluation. She ended up not using Dr. Webb, hired Dr. Clark, who had the first opportunity to evaluate her, and he just wasn't finished with his evaluation when the state's expert, Dr. Pickett, began his evaluation. And importantly for this point, again, is the fact that Gregg didn't object to any of this occurring. There was never a point in time where the trial court said he was going to appoint experts to conduct monotone evaluations, that Gregg said, no, we object to that, we don't want her evaluated, we're not going to plead insanity. Her only request at any time was that her expert evaluate her before the state's expert. But even when the state filed its formal written motion seeking to have her evaluated under monotone, Gregg did not object, and in fact, in the trial court, it asked, do you have any objection to the state's motion? And they said, no, Your Honor. So I think that any argument she makes that she should not have been evaluated under monotone before filing her 17.4B notice is really mooted by the fact that she herself acquiesced to being monotone evaluated even before filing that 17.4B notice. Your Honors, if you don't have any further questions on any of the issues, then the state would rest on its brief and urge this court to
Just done early.
affirm Gregg's convictions and sentences.
Any questions for Ms. Hartman? Thank you, counsel.
Thank you, Your Honors.
Right.
All right, Mr. Murphy.
Rebuttal. Ineffective assistance of counsel, that seems to be your strongest argument right now.
How much time do I have?
10 minutes.
Please, the court.
You can use 20, though, if you want.
I'd like to address a couple quick points, if I may, before I move on to some more substantive argument. I believe it was Justice Sullivan who asked counsel whether the legislature could have, whether it's possible that the legislature intended for life in subsection 2B as it applies to juvenile first-degree murder, whether the legislature could have intended that that be life with parole irrespective of the parole statute, and counsel responded, possibly. I think that is very telling, in that I think at the very least, while we would assert that it very certainly does indicate that the legislature intended that, but we would assert that the state has now conceded at the very least that there is some ambiguity as to whether the state or the legislature intended that or not. And as I think the court is well aware, the brief that we cited, we included all of the canons of construction when the court is interpreting statutory construction, and one of those rules is the rules of leniency. And the leniency rule states that if there is a distinction to be made, if there is an ambiguous statute, and there are two interpretations, the interpretation that is most lenient to the defendant is the one that the court must adopt. And in this case, that adoption would be that the statute that was amended and in effect at the time of the sentencing is that Carly's sentence is life with the possibility of parole. I'd like to make that quick point. And also, Your Honor, I'd like to address, Your Honors, I'd like to address the state's reliance on Johnson v. State. 2 points I'd really like to make about that and why the state's reliance on that is misplaced. Number one, I believe it was Justice Coleman who pointed out that was decided well prior to the amendments to the statutes and in response possibly to Miller. But that case involved a very thorough Miller sentencing hearing. And that is distinguished from this case because there was no Miller sentencing hearing. There was, and again, I've used that term loosely, there was a sentencing hearing, but that was very, in effect, it was a sentencing argument. So in the case at bar, unlike in Johnson, we had no sentencing hearing, and I believe Miller not only stands for the proposition that there are certain factors that a jury or a trier of fact or whoever is deciding the sentence must consider. You can't just throw all these factors that the jury must consider at the wall and assume that they're going to consider them. So there's a substantive aspect to Miller, but there's also a procedural aspect to Miller. In other words, is the defendant given adequate process, adequate notice, and an adequate opportunity to address those Miller factors? And in this case, there was absolutely no notice that we're moving into the sentencing phase. I'm not even sure, prior to the court turning to the state and saying, present your first sentencing witness, I'm not sure whether the litigants were even aware that that was going to happen. I certainly don't see anything in the record where the sentencing order or anything like that outlined that that was going to happen. But certainly the defense was not afforded any due process to address those Miller factors. And so we would move or posit that Johnson is really inapposite to Carly's case. Another issue that we would point out, and I'm just going to read from our brief, the state's reliance on Johnson v. State is misguided. According to the state, and I'm quoting from the state's brief, this court held in Johnson that the trial court's application of section 4773 to sentence Johnson, who was 17 when he committed first-degree murder, to life imprisonment without the possibility of parole after a Miller hearing was not an abuse of discretion. Thus, in harmony with Miller, section 97.3.21.2b allowed Carly Gregg's jury to sentence her to life without parole, consistent with section 47.3.d, which is a parole statute, but only after it considered the Miller factors. However, The trial in Johnson occurred in 2000, as I think Justice Coleman and Justice Sullivan and perhaps a couple of other justices pointed that out. The trial in Johnson occurred in 2000, nearly 2.5 decades prior to the amendment to 97-321 from Senate Bill 2022 of our 2022 of our legislature's regular session in 2024. And now, if I may, we did not address this in the initial argument, but I would like to address one of the errors that we have alleged that the defense did object to, and that was the introduction of the crime and punishment summation by Rebecca Kirk, who was one of Carly's counselors. During the state's rebuttal case, the state elicited testimony from Rebecca Kirk, who was, again, one of Carly's counselors, to summarize. Well, first she was asked what books Carly had read or was going to read, and there were several books that were mentioned. One of them was The Bell Jar, another was The Castle, and then there was Crime and Punishment. Curiously, the state did not ask Rebecca Kirk to summarize The Castle or The Bell Jar. The only one that they asked Rebecca Kirk to summarize was Crime and Punishment. And this was over objection of defense counsel. And this was over objection of defense counsel after pointing out to the trial court that there's no proof that Carly even read the book at the time of the trial. Now, we would dispute whether or not that was ever established. I think in cross-examination, I think defense counsel got Ms. Kirk to admit that maybe she said she was going to read it, but she hadn't definitively read it or not. But whether she had read the book or not is really irrelevant. The plot of that book was a sensational plot that, as summarized by Rebecca Kirk, it was about a hatchet-wielding murderer who tried to assert the defense of insanity and then got away with it and was unremorseful and unrepentant. That was the summation of Rebecca Kirk. Now, not only would we assert that that was an incorrect recitation of the actual book, but at the very least, it was the important points that Rebecca Kirk remembered about the book. It was not the important points that perhaps Carly Gregg would have remembered about the book. But be that as it may, the only reason that the prosecution would want Rebecca Kirk to summarize that book is because the prosecution wanted that jury to hear those sordid details about that book and associate those details with Carly Gregg. They wanted the jury to think, well, if she read that book, she must have been she must have had those thoughts, and she must have hatched the plot to plead insanity after she read that book. That is exactly what the prosecution wanted the jury to believe, and that was over the objection of the defense. Now, I believe it was Justice King, and I believe Justice Coleman joined Justice King in an objection in Jordan v. State, which was an en banc split decision by this court rendered in 2016, which was reviewing a affirmation of an appellate court. The Court of Appeals affirmed a finding of guilt after the prosecution was allowed to introduce rap lyrics.
Rap lyrics.
The Court of Appeals affirmed the conviction, and then the Supreme Court was split evenly 4-4. Again, I think Justice King filed an objection. Justice Coleman, I believe, joined in that objection. And there were several things that Justice King cited in his objection.
I guess you could just leave it there. Or
and I believe that court cited with approval a New Jersey case, State versus Skinner. In that holding, in State versus Skinner, the New Jersey Supreme Court held that lyrics were highly prejudicial and carried little or no probative value because they were expressive, fictional writings and not tied by a strong nexus to the charged shooting in that case. Just as in this case, there is no nexus between what the writer of Crime and Punishment wrote and what was alleged that Carly did. There was no nexus. It was not even established that she had read the book. And I want to read a quote because I think it's extremely instructive from State versus Skinner. The difficulty in identifying probative value in fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because an author has chosen to write about certain topics, he or she has acted in accordance with those views. One would not presume that Bob Marley, who wrote the well-known song I Shot the Sheriff, actually shot a sheriff, or that Edgar Allan Poe buried a man beneath his floorboards as depicted in his short story, The Telltale Heart, simply because of their respective artistic endeavors on those subjects. The defendants, in that case, lyrics, should receive no different treatment. In sum, we reject the proposition that probative evidence about a charged offense can be found in an individual's artistic endeavors, absent a strong nexus between the specific details of the artistic composition and the circumstances of the offense for which the evidence is being adduced. And I would take that a step further. That case, and these cases that we cited in our brief, including Jordan v. State, Brooks v. State, United States v. Curtin, involved artistic works that the defendant was alleged to have written or participated in some form or fashion. In Carly's case, the artistic work at issue is a book that she had absolutely nothing to do with writing. She did not write that book. She had absolutely no contribution to the themes that were found in that book. So we would submit that the propositions cited by Justice King and Jordan v. State, by the Jersey Court and State v. Skinner, by the Ninth Circuit and United States v. Curtin are even more applicable in the case at bar than they were in those cases. And we would argue that the court erred in allowing the state to introduce that testimony.
Thank you, Mr. Murphy.
Thank you. You're done. 1.5 minutes.
If there are no other questions by the justices.
You're done.
Thank you, Your Honors.
Ms. Hartman.
Last word.
Mr. Murphy did not mention the crime and punishment argument during his initial presentation. Out of a sense of fairness, if you'd like an opportunity to respond to that, the court will give you a couple of minutes.
Thank you, Your Honor. May it please the court. So the majority of Gregg's argument for crime and punishment is essentially relevance, and that any relevance it did have was more prejudicial than probative. But that's not the standard. The standard is under 403 whether the probative value is substantially outweighed by the risk of unfair prejudice.
Well, Counselor, first you do have to answer the relevancy question.
Yes, Your Honor.
So there's no evidence that Ms. Gregg read that book, correct?
I would disagree with that, Your Honor.
She said she told the counselor she wanted to read the book.
And then she told her that she completed the reading.
Oh, she did say that?
Yes.
I'm sorry. Where is that in the record?
Let me see if I have that written exactly down here. I don't have that citation on my outline, but it is in our brief. I argue that point in the brief. So I know that I cited it there. And essentially, Rebecca Kirk and Gregg discussed those 3 books before spring break, and then they went on spring break, and then the appointment right after spring break, Gregg told Rebecca Kirk that she had completed the reading. So I think from that, it's a fair inference that she read the book.
So, I'm sure you're correct. I'm sure that's in there. So assuming that it is, I still ask the question, what disputed fact in this case does that her reading of the report that she read that book make more or less likely to be true?
I think because the defense put on an insanity defense and they called Dr. Clark to the stand to testify that Gregg was criminally insane under Monotone. He testified that he relied on Rebecca Kirk's treatment notes, and then the state called Rebecca Kirk to rebut Gregg's insanity defense and rebut Clark's testimony about her Monotone insanity. So it's our contention that that's relevant. Her state of mind, the materials she was ingesting, the discussions she was having with her therapist, even about these difficult and complicated classic books, bore on Rebecca Kirk's testimony about her treatment of Carly Gregg, even just 24 hours before Gregg went and murdered her mom. So I think that Rebecca Kirk's treatment notes, including that reference, are relevant to the state's rebuttal of her insanity defense. And Your Honors, even if this court is inclined to hold that Rebecca Kirk should not have been permitted to testify about the summary of crime and punishment, I think this is a classic example of harmless error because Gregg was not convicted because Rebecca Kirk summarized crime and punishment on the stand. She was convicted because the state presented extensive and overwhelming evidence that she was sane at the time when she murdered her mom and that she committed the murder with deliberate design. Just a few examples. She appreciated where the security cameras were in the kitchen. She hid the gun behind her back when she was in view of the security cameras so that the camera wouldn't see it. She covered her mom's face with a towel after she shot her point blank in the face 3 times. She called multiple friends on the phone and said things like, "I messed up, don't call the police," things that would indicate that she knew what she had done was wrong. She even took her mom's cell phone off the counter right after she murdered her, put in the correct passcode, and then went in the phone, found Heath's contact information, and texted him and asked when he would be home, acting like Ashley. This and abundance of other examples prove that Gregg murdered her mom with deliberate design, but more importantly, that she understood the difference between right and wrong when she murdered her mom, so she was sane under Monotone. So, irrespective of the crime and punishment summary, Gregg would have been convicted, and this court should affirm her convictions and sentences. Thank you, Your Honors.
Thank you, counsel. The court appreciates your arguments and will take this matter into advisement and render decision in due course. We stand adjourned.
All right, that completes the hearing. They never make their decision in the moment, but we'll let them file out. And the feed's going to drop. There we go. All right, big thanks to the state of Mississippi, the judiciary, for the Supreme Court for granting us permission to use their clean feed. Let me kill the other stream. Actually, I can do that over here. Hang on. Hold, please. Done. Okay, I think we're good. All right, interesting. We followed that case with Carly. The thing that stuck out to me from that trial, I don't remember all the details of all the trials, but the thing that stuck out to me on that trial was the sorry, it's a spam caller. I'm not taking it. Was the video, the home video, the security camera footage. That it appeared that Carly was aware of the camera and the angle it was at and how she was holding the gun to hide it from the camera, and just how matter-of-factly she did what she did. It was very telling, and I think the jury did get the verdict right. And if I could read the tea leaves as far as what the state of Mississippi might do as far as the Supreme Court here, she's obviously not getting a new trial. I just don't think they didn't even argue the ineffective assistance of counsel other than mentioning it once. I thought that was their strongest point, which is bad because they didn't even argue it. I think they do have a legitimate reason to say we need a new sentencing, redo the sentencing. But the problem is, redoing the sentencing, that's the part that was all confusing. The convolution between the legislature says you can't grant somebody who's found guilty of first-degree murder parole, and so there's life without parole, and then there's life, but you can't say with parole, even though it might be parole, but you can't give it to them. It's all confusing. The legislature has to address that and fix that, and yeah. So we'll see what happens. I think life without parole is a very long sentence for a 14-year-old. I don't know. I've always believed that even people who do pretty bad things can change their life around, and a lifetime is a long time to not. I mean, at 14. I have a hard time with that. But at the same time, I do think she should have been tried as an adult. So there you go. All right. Yeah, they need to make it more clear. Maybe the legislature would act a little more proactively in this area if the Supreme Court would rule a little more reactively to the legislature's inaction. Does that make sense? The legislature might act because the Supreme Court says, well, we're looking at the rules, and it looks like we have to do this. And if the legislature doesn't like that, they can change it. All right. I think it was 3 times in the face, right? Yeah. I mean, it's terrible, Virginia. I'm not, I mean, she was, I look at her and I see in her the same thing we saw in the Slender Man suspects, the Slender Man murder things. It's just at that young of age, to have the light out of their eyes, just the dark. It's just, I don't know, something's broken on the inside, but it might be something that's still able to be fixed. So, all right. With that, where are we? Camera 6 is still there. We're done there. We're still waiting. I'm going to try to get a hold of South Carolina again. If not, we're going to have to do fair use and I'll pick up on that trial, I think, because I want to follow South Carolina versus Chow. That's for sure. Allie B, yes, we put in our request. We're supposed to be on the pool feed. It's weird because, in talking to him, we got bounced around, and I think the problem was our request went to the wrong person, or the wrong person failed to act on it, and then they were supposed to send it to someone else, and the person they sent us to is now busy with a trial and trying to get that person to give us the heads up and the okay, which is how we operate. That's the hard part. So I'm a little frustrated too. She's in a juvenile facility right now, I believe. She was 14 at the time. She's 17 now. We can zoom. We can catch up for sure. And I think we might do that starting after the break. Is that okay with y'all? Should we chow after the break? We can go get some chow, and then we'll come back and follow chow. Unless there's any objections. Yes, lunch break. Yay! All right, let me build the portal and grab the chow.
I'm going to sustain my own objection.
I think Red already made a chow thing for us. Hang on. Mrs. R.A. made it home safely, by the way.
Are we going to address subject matter jurisdiction?
I'm looking for chow, but I'm not seeing it. There it is. Found it, Red. Thank you. I love this one, too. Okay, we're building a quick portal here. We're not going to be in that court. We're not going back to Warren County. Sorry. The goal is to go back to
a good path,
this one.
since that would likely potentially make, I think, the issue worse and be intimidating to.
That's our goal. So we'll get caught up there. We'll choose the wrong thumbnail for the two, I'm sure. No, I'm going to choose the right one. I think I'm going to try. So. Subscribers, no live reactions, visibility. It's 12:45 right now. Let's go ahead and do a 1. Can we do 2 o'clock? Is that all right? 2 o'clock, because we'll be catching up and be able to fast forward and stuff. All right. Barbara Taft, I'm trying to remember the name of the lady that the husband in Georgia did something to his wife. They still can't find her body. And that describes like 15 cases. I can't remember the name off the top of my head either. Somebody else knows it. Likes to give me a choice. I usually choose the first one. Have you noticed? Okay, building the portal as we speak. And now I have to build the picture of the other one. And correct the name. So it's not SCS. SC. Pin the image. There's Chow. And save. All right. Now we're ready. Sorry, it's some of the things are one-man show, but running the live stream, like chat and involve, everything else, that takes a full team of mods, and I couldn't do this without them. Thank you very much, mods. You're absolutely amazing. Did you get my milestone message? Yes, during the show. I couldn't say it, but Melissa, 28 months. Favorite place to be, even if I have to lurk most of the time. Love this place more than anywhere else online. Melissa, that makes you an OG. And Blue Star coming in with 9 months as well. Thank you. Rybear, 25 months on the jury. Thank you very much. TTU Gator, 23 months, also an OG. We had a few before. DSN gifted 5 memberships. GG Sharebear, 32 months. DSN, 39 months. Skybell, 34 months. All of them OGs. All right. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again at 2 o'clock. 2 o'clock. Andrew JC, 37 months. That's awesome. Congratulations. OG. All right, we're going to go live at 2 o'clock. We're going to be catching up on the South Carolina versus Chow case. I'm not sure what I can do on the audio. I'm going to do my best to make it a little bit better, but it's rough. It's rough. Bring your Excedrin and Aleve and acetaminophen and ibuprofen and everything else, all the other painkillers, because we might need it. All right, guys, have a good lunch. We'll see you.